Yes.
The compelling circumstance mentioning on matter yesterday, mentioned lordship asked me to mention after service of notice upon the
Application, na? Yes.
My lord, with the kind leave of Honorable Justice Ritabrata Mitra, my lord, the OBC matter which my lord had directed yesterday to put in the sleep, my lord.
What has happened?
My lord, it has happened like this, that on 1st of June, the merit list finalization will be there. 1st of July. 1st of July, that is on Tuesday, the finalization of merit list will be there. Now the admissions with designated as OBC, purportedly under OBC A and B applications are being invited. My lord, 71,000 application had on 18th June.
Conducted by whom? The State Service Commission?
My lord, it's under the West Bengal Higher Education Department, my lord. It's under the in the portal of West Bengal Higher Education Department, and the portal was started after your lordship's order on 18th June, my lord. 17th June, your lordships were pleased to stay there at that. My lord, kindly.
Thursday 2 p.m.
And my lord, I will pray for one more indulgence. My lord, it is a contempt proceeding. My lord, kindly allow us to serve tomorrow and
let it appear. That way it cannot be. Satisfy us then. CGR has to be followed. Na? Thursday 2 p.m. Yes, call the.
My lord, may I mention one urgent matter inclusion your lordship list. This matter, my lord, returnable.
It's not the mentioning day.
My lord, it is a.
Remind us on call the list. What happened? Settled?
Yes, yes. My instructions.
Milord, we need some time because the affidavits that were sent to them, Milord, that could not be executed because the lawyer concerned, Milord, is a very senior lawyer, Milord, in the court below. Milord, he was having some personal difficulty, Milord. He could not, and at the same time, that is 119 affidavits, Milord, could not be affirmed before the district, the concerned, Milord, the judicial magistrate, and he said, Milord, that
Mr. Vasu, we send it out of list then. You arrive at that and come and mention before us. You have any objection?
আরে তোরাও এফিডেভিট করবে আমার এফিডেভিট
আমাদের এফিডেভিট হয়ে গেছে
আমার পক্ষে আমাদের লয়ার ওখানে সিনিয়র লয়ার সে বললেন
কি এফিডেভিট জয়েন্ট এফিডেভিট তো
না সিঙ্গেল এই ইন্ডিভিজুয়াল আলাদা করে সিজিএম বলেছে একসাথে এতগুলো হবে না
10 দিনের মধ্যে
লয়ার তো ও তো লয়ার তো ওনার চেনা তো
এটা 15th জুলাই রেখে দাও 15th July
affidavit and the settlement agreement, Mr. Vasu. The settlement between the parties will also.
Yes, they have put their respective hands on the agreement, Milord, and they are also affirming an affidavit.
Agreement signed.
Yes.
To the best of my knowledge, Milord, the agreement is signed.
No, in that those clauses were there. All clauses are there. Then what you are?
Milord, the undertaking, Milord, that they both the parties in Milord in the agreement, Milord. They want to file an undertaking before your lordship's court, so that, Milord, in the event, Milord,
that was because there are
we are 25 in numbers, Milord. The others are not party in this proceeding. That is why the affidavit was required. Milord, my junior is requesting, Milord, subject to kind sanction, instead of 15, Milord, maybe on 22nd or Milord 23rd. 24th.
Why? What is the?
Because, Milord, the learned lawyer, Milord, he says, Milord,
28 July.
এটা আমাদের
আমাদের কোনো case institute
Hey,
করিনি।
28th July. You are carrying on the construction, na?
Yes, yes.
yes yes
There is no problem in that.
No, no,
So if you feel any problem, you come and mention.
right.
to us. Let the work go on as we
Yes.
have directed so that they can be accommodated also.
We had
On the joint prayer of the parties, the matter stands adjourned. Stop. List the matter for further consideration under the same heading in the daily supplementary list of this court. 28th July. Any interim order is there?
no, no. The interim order is not to allow the construction to go on. I mean, there was no
No
impediment.
time limit was
No, no,
there?
no.
ঠিক আছে, চলো।
My lord, in this matter, my lord, I am for the appellant. My lord, the service of the private respondent is not effective till date. My lord, kindly shifted, my lord, next week.
Then why did you give the returnable date? Was it heard by us earlier?
Yes, yes, yes.
হ্যাঁ হ্যাঁ immediate experience. আপনি check করে fourth আচ্ছা 24 তারিখ তো 24 তারিখ 9th 15th July রেখে দাও 15th July. Yes.
I can see him appearing for the appellant. That's your affidavit. Lordship, by the 16th, they were supposed to give the affidavit. in
Today we are affirming this affidavit millet will be served millet by today millet.
what affidavit?
The affidavit was not served upon them millet. It is affirming today millet. We will affirm. We will serve today millet. Kindly takes it up any day on the next week.
What? It's an opposition reply. What is this? What
They will
Opposition.
You're not minded to file a reply?
They have not given till now, Your Lord. Yes, yes, Your Lord. I will be filing my reply 2 weeks time after that.
অর্ডার শিটটা দাও সাহেবকে।
I am appealing for the appellant, my lord.
But I appear for the blood marketing board.
But these are two appeals together, my lord. But the first writ petition was challenging the 2008 amendment to the 1972 Agricultural Marketing Produce Act and 2014 amendment and 2017 amendment. On a very short ground, my lord, the initial parent act was on the basis of presidential assent. The amendments which were incorporated, enlarging the schedule.
When the original writ was filed, my lord, there was no such, my lord, the prayer with regarding the, my lord, the challenging the iris of the act. After, my lord, that there is a modification, amendment to the writ, and then, my lord, inserted.
Yes,
there.
whatever it is, my lord, after amendment.
But
we
there
have
are two
challenged
writ.
subsequent amendments brought to the parent act, principally on the ground that the amendments were not by way of presidential assent. And the amendments purported to change the entire gamut and scope of the act.
With no nexus.
I will tell your lordship the reasons therefore, but today, my lord, we are more concerned with the second appeal. Because in the second appeal, there was the second writ petition which was filed was on the basis of an assessment order done by them. Initial assessment order was of 19th of April 2016. In the earlier round of litigation, that assessment order was set aside with a direction upon the authorities to consider the documents and returns and thereafter come to a fresh assessment order. So the second assessment order which came to be passed, that we have challenged in the second writ petition. Both the writ petitions were heard together, one after the other, my lord. Once the first writ petition was dismissed, saying that presidential assent is not necessary, there is no finding in my respectful submission with regard to the second writ petition at all. Whether, even assuming, my lord, today what I am going to, for the limited purpose of stay, I am going to urge this, my lord, even for the timing, if your lordship assumes that the amendment brought by the 2008, 14 and 17 are proper, even then, can this assessment be sustained? Because there are two grounds, my lord, which I am taking. Number one, my lord, if your lordship sees the last amendment, these two products which we are manufacturing, I say manufacturing, these are not covered by the schedule of the amendment. So if these two products are not covered by the schedule of the amendment, well, then there is no question of levy of market fee on these two products. That aspect has not been considered by the assessment order. Writ court, my lord, has not gone into the assessment order. There is not a single line on the assessment order at all. My lord. And the second aspect is, my lord, the effect of this Marketing Produce Act is with regard to levy of fee within the market area. My lord, suppose I am operating in Burdwan. The sale within Burdwan area has to be considered and market fee has to be levied on the sale within Burdwan area.
And the assessment order.
Yes, Lord. I'll show you, lordship.
That is in the second appeal, 759.
758. 758. 758 is the appeal from the second writ petition.
It's one common order, Mr. Sen. One common order.
Yes, yes, one common order. No. Assessment order. But
758.
My lord, kindly come to page
758.
217 of 758. দেখাচ্ছি। My lord, if you are- 758. 758 of match 758.
Assessment order.
Assessment order. It has page 217. It starts at 217 in match 758. That's the covering letter. Then from 218, the order will start.
So did you enjoy any interim order in the writ petition?
My lord, after the writ petition was filed, what happened, my lord? They initiated a recovery proceeding under the Bengal Public Demands Recovery Act. That proceeding, and that was initiated when the matter was made CAV and judgment was awaited. So that at that stage, the Honorable Judge directed that no coercive steps should be taken. But previously, my lord, there was no interim order. There was the original assessment order, which was subject matter of writ petition. We did not enjoy any interim order during the pendency of the writ petition. When the matter was, after the matter was heard, this proceeding was initiated under Bengal public demand. That when we pointed out, that proceeding was stayed, my lord.
No, in the writ petition where the vice of the amendment was challenged, in that you also challenged this assessment order.
Simultaneously, we filed a second writ petition challenging the assessment order. So both the writ
which was on the assessment on the basis of the amendment made.
amendment made.
So that assessment order was under challenge. You did not get any interim order. However, when they initiated Bengal recovery,
Yes. Then there was the court said because the matter was already made CAV by that point of time.
Oh, I see. I see.
So the court said they should not take any recovery proceedings any point of time.
So
Here,
when you did not enjoy any interim order pertaining to the first assessment order, why should we give you?
Yes, my point is, if your lordship sees, so there, the writ, your lordship is now seeing the impugned order passed by the learned single judge.
Right.
Now,
which involves the challenge against the amendments as well as the assessment.
Assessment order. Insofar as the assessment is concerned, my lord, there
is no finding.
There is no finding. And I am, my lord, the prima facie case which I am now trying to make before your lordship is on the premise that even assuming that the amendment is valid, lordship proceeds on the basis of amendment. Your lordship will be hearing the appeal, substantial appeal on the amendment later stage. That is what I want to show. The assessment order could not have been passed even assuming the amendment is valid.
So please show us that relevant portion.
Yes,
of
that relevant portion, if your lordship kindly sees, kindly see two issues which have been identified at page 219. Points raised for determination by the assessee is here under.
219 is the assessment order.
Yes, 219 is part of the assessment order.
No, you said that the single judge did not
No,
make any
your lordship wants to see the impugned order of single judge. I am showing your lordship the assessment order first.
We want to see that.
Very well. I'll just come to
the veracity of your argument.
Yes,
that the assessment was not dealt with.
Yes. I'll just show you. The impugned order, my lord, is at page 50 of 758. Starts at page 50. Your lordship will come to the last paragraph of the order.
Page 50.
50. Your lordship will come to page 84. Paragraph 58. May I place, my lord?
Yes.
For all the reasons as discussed above, the court finds that the challenge as to virus of the West Bengal Agricultural Produce Regulation Amendment Act 2014 and Amendment Act 2017, and also the notification dated January 29, 2002 and dated August 22, 2008, that those are ultra-virus is not sustainable. Reasonableness of the impugned legislation challenged principally on the ground of non-compliance with proviso to Article 304B of the Constitution, or imposing double taxation upon the petitioners, or that the levy not being in compliance with principle of quid pro quo have not been substantiated in the instant case by the petitioners. The legality and the propriety of the same as challenged in the petitions are found not to be maintainable. On the other hand, it is found that the fees imposed is in the nature of regulatory fee, not challenged to be excessive in nature. Hence, being devoid of any merit, writ petition number such and such 2019 are dismissed. The 2019 writ petition is the challenge to the assessment order and the appellate authority's order. Both are challenged. The petitioner company is held to be liable to duly pay the amount of market fees as per demand. My ground of challenge is not dealt with even by a single line, with the greatest of respect. So, therefore, my submission.
Apart from the virus issue, was there anything else to be challenged?
Yes, that is what I'm saying. Why? That is what I'm saying, my lord. At least for the purpose of even as once the court held that the virus cannot be challenged, amendment is valid, then the question arises that even under the amendment,
whether the assessment is
are
good or
these
bad.
two products which I am manufacturing subject to, is an agricultural produce within the meaning of the act and subject to market levy of market fee? That is the first question. Second question, my lord, which arises is, because this act also prescribes the market area within which the fees can be levied. Section 17 particularly says that the sale has to be within the particular market area. I have given them the returns with regard to Badwan market area, and they are not issuing me the certificate on the basis of that Badwan market area. They are saying you are selling outside also, and that outside sale return you should have given, and therefore I will determine market fee on the basis of outside sale.
All right, take us to the assessment order. What do you want to show? That page 200
Yes, 218, 219, these are the two specific issues which was framed at 219, 1 and 2. Whether refined rice bran oil or de-oiled rice bran manufactured by the company or agricultural produce within the meaning of 1972 Act on the ground stated therein. Number 2, whether under section 17 of the Act, market committee entitled to levy market fee on the sales conducted in the area which fall within jurisdiction of market committee within Badwan district, though no such services are provided as prescribed under the Act. Now, Lord, kindly come to the page 220. Now, my lord, before I go on to this, let me first show your lordship the schedule. As per the last schedule of the Act, 2017 Act, these two products which they mention, these are not included in the schedule.
Which two products?
These two products, my lord, which is mentioned, refined rice bran oil or de-oiled rice bran. Issue number 1. Products have been mentioned.
These are not in the schedule.
These are not in the schedule, my lord. It was earlier. 72 Act was there. Then it was removed. 2002, from the 2002 amendment, the changes is taking place with regard to the items. My lord, I am showing your lordship, my lord, these first, this is which.
So this removal was on the basis of the amendment. So then amendment, why you are challenging?
Lord, amendment I am challenging
Amendment
because
goes
of
in
the
your favor.
definition of agricultural produce. Definition has been expanded to bring in manufacturing process also. My lord, pisciculture, processing of foods, everything. I will show your lordship the definition why I am challenging. Because schedule is only incidental. First, it has to be the agricultural produce within the meaning of the definition. And if the scope of the parent act is only protection of the farmer's produce within the regulated market area, as per the object of the parent act, if your lordship will take, my lord, the last act, I'll show your lordship the definition. How the definition has become wider. Schedule A45. I first show your lordship the schedule.
But Mr. Sen, what would be the quantification of this levy? Assuming that it is this assessment order is right, then what will be the computation of the levy which you are required to pay?
That they have computed here.
They have computed?
Yes, they have computed. And what is the most surprising thing your lordship will see?
But you are showing us the 30th June 2016 order at page 280.
Yes, thereafter there was before the appellate authority.
Very good.
This was affirmed by the appellate authority.
So they will be now implementing this assessment.
Yes, yes. This assessment.
So where is the quantification?
Yes,
17 lakhs?
Yes,
1,474 lakhs.
I'll just show your lordship. But before that, if I may show your lordship the finding, my lord, kindly come to page 222 of the assessment order. Certain things, my lord, which have not been considered at all, my lord.
So you secured that amount?
But
Secure the amount, we will stay the.
there is no adjudication at all. Complete no adjudication. And I am saying, well, you considered the amendment.
You secured the amount, get the interim order.
Well,
Prepare the paper.
Well,
we
I,
release
well,
the-
I'll tell you, Lordship, well, kindly see, well, the assessment is towards the amendment.
You will get it back, Mr. Sen.
Well, it is, well, after all, if I make a prima facie case, your Lordship will protect me. I am only on that limited aspect, my lord. And not only this, my lord, I'll tell you, Lordship, this is the second round. Same amount was assessed on 19th of April 2016, challenged in writ petition, set aside by the order of this court. And they say same assessment amount. I'll show you, Lordship, the previous order, how it has come back to here. There was a previous assessment of 19th of April.
Where is that?
My lord, kindly come to page 210. This is the order of the earlier court, writ court, my lord. My lord, kindly see page 2101. Once, my lord, 2nd of May 2016 order.
Yeah, just a minute.
তৈরি করেনি না নোটিফিকেশন গুলো
বসেনি কেন পাঁচ কোটি 92 সাবজেক্ট ম্যাটার সাবসিকুয়েন্ট ওই যে উপরে যেটা আছে 13 থেকে 16 ব্যাস এটা কেস করুন রিট করুন তারপর এটা নিয়ে এখন কোনো উচ্চবাদ ছিল না ইস্যু ডিম্যান্ড করেছে হবে 11,500 এই দুটো সাবজেক্ট ম্যাটার
Yes, page.
page 210.
This is the reach court order.
Yes, by which the earlier assessment order was set aside. My lord, kindly see second paragraph. WP 7788 is directed against an order of assessment dated 19th April 2016 made by the secretary. Impugned order, petitioners have been required to pay market fee assessed at rupees 1,74,00,000. Same demand now again. Impugned order was made in compliance in the writ petition. Notices dated issued by the secretary calling upon him to appear before him with valid documents. According to the secretary had no authority. Order dated such as are required to meet the secretary. Then, my lord, lordship will kindly come to last part of the order, page 212. In that view of the matter, bench is of the further considered opinion that interest of justice would be served if impugned order dated such and such is set aside. Appropriate directions are made to facilitate a proper assessment order being made in accordance with law. Impugned order is set aside. Petitioner shall be at liberty to submit written notes before secretary. All points that are available to them as raised in this writ petition, not to make an. I'll show your lordship the specific point I have raised in my written note. Requiring, kindly note this line, to persuade the secretary not to make any order requiring the petitioners to pay market fee on agriculture. It shall be open to urge that the products manufactured by them.
Where you are reading?
My lord, page 212.
212.
Yes, operative part. The following directions are accordingly given. Impugned order dated 19th April 2016 is set aside. By 9th May, petitioner shall be at liberty to submit written notes before the secretary raising all points that are available to them in law and as raised in these writ petitions to persuade the secretary not to make any order requiring the petitioners to pay market fees on agricultural products. It shall be open to the petitioners to urge that the products manufactured by them are not agricultural produce covered by the schedule of the Marketing Regulation Act 1972. That is the point which we have urged, that rice bran and de-oiled rice bran are now no longer agricultural produce. Then, my lord, your lordship will kindly see subpara 6 of this order. The secretary, upon inspection of the documents as well as on consideration of the written note that the petitioner might file before him, pass an appropriate reasoned order of the assessment touching all points raised by the petitioner, and also in the light of the earlier order dated 12th April 2016. So, my lord, I show your lordship, my lord, two provisions of the amendment, my lord.
And what happened before the secretary?
This is the assessment order which is passed, which we have challenged now. And your lordship will find exact same amount as per 19th April order. So there is no question of revisiting that order by the secretary now. But most important thing, my lord, he will have to justify that even after the amendment, if these two particular products are not covered.
Did you urge that before the single judge, this point, which your schedule point?
Rice bran is not an agricultural product. The rice bran oil. Did you urge it?
That, my lord, it has been recorded in the impugned order itself, assessment order. No. He himself says, frames the question.
Did you urge before the learned single judge?
My lord, I was, but it appears that the writ petition is there before your
The assessment order says clearly that rice bran is an agricultural produce under section 2.
Let us see, my lord. It will be appear from the schedule itself.
So, you have to see if you had taken this point before the learned single judge.
Lord, with that I will have to check. But I'll tell you, lordship, my lord, principally the argument before the single judge, since the two matters were clubbed together, principally it was on the question of virus of the amendment. Principally, we had questioned that if the amendment goes,
then your liability goes completely. Alternatively, even if the amendment stays, but you say that rice bran is not an agricultural produce, then I don't.
Then anyway, I don't have a liability.
Either way, I don't need.
Anyway, I don't have a liability.
When did the amendment come?
2000. There are two amendments which are all the
prior to the writ petition challenging order of 19th April.
Yes, 2014 amendment is prior. But the last amendment is of 2017.
That is after the assessment order was challenged by you.
Yes. No, I had challenged the assessment order in 2019. The final assessment.
No.
Before Justice Dotto, my lord, yes. It was of 2016 writ petition. So at that time, the 2014 amendments were there. But at that stage, the writ court did not go into the schedule. What was the schedule? What was the amendment? That is on procedural impropriety and authority of the secretary. The order was set aside. If your lordship sees the internal pages of the order.
Yes, Mr. Sen.
But if they must show your lordship two parts. First of all, may I tell one thing? But if your lordship takes the act, my lord, I have placed A45. Kindly come to, my lord, the page number is mentioned as A45, where the schedule is given. Kindly see, these are the clauses of the under serial, rice is mentioned. My products are, my lord, rice bran and de-oiled rice bran.
So this amendment you challenged?
Yes.
This was in your favor.
I had challenged on the basis of the definition of the.
Where is the definition?
Definition, your lordship will kindly come to section 2.
Agricultural produce.
Yes, agricultural produce.
This was amended in 2014 Amendment Act.
Yes.
What was brought in?
Yes. This part. Whether processed or unprocessed of agriculture, horticulture, apiculture, pisciculture. I have prepared, kindly see the changes which have been brought about by the various amendments from time to time. How the definition that I am giving your lordship is typed out, it has been. Yes.
ও বলছে jurisdiction-এ নেই। ও বলছে আমি টাকাই এইটা আসেই না আমার থেকে
Kindly see, first is the original section. What was the original section, my lord? In the 1972 Act. Produce means produce of agriculture. Notwithstanding contained in any other law relating to taxation of agricultural produce in force, the market fee committee shall levy fee on any agricultural produce purchased or sold in the market area. Now, my lord, market area, your lordship will kindly come to section 3. Declaration of market area. By notification, declare any area as a market area within which purchase and sale of such agricultural produce as may be specified in the notification shall be regulated. So by schedule, they bring different market area into consideration. I have no quarrel about that. But one market area I am paying. What they are saying, even if you are selling outside but one market area, I am exporting. I am selling in a different state. That return of sales they have taken from my balance sheet and accounts, which is beyond the market area. That your lordship will kindly get in section 17. Kindly see, this is specifically provided here. So 17.1 I placed, my lord, that levy fees on any agricultural produce purchased or sold in the market area. Now kindly come to, my lord, proviso. Provided that no fee shall be levied in the same market area more than once in relation to the agricultural produce, irrespective of the number of transactions. Suppose I go and sell in Midnapur. I pay in Burdwan once. I shall not be liable to pay in Midnapur again. Now kindly see here the explanation. Explanation 1. That is the most important thing which has not been considered by the assessment order. For the purpose of this subsection, all agricultural produce taken out or proposed to be taken out of a market area shall, unless the contrary is proved, be presumed to have been sold within such area. So I have a right to rebut the presumption that it has been taken out and it has been sold in a different place. That presumption, this has been taken to be an irrebuttable presumption. Despite me producing the documents to show the contrary presumption, to rebut the presumption, this has not been considered. This explanation does not feature in the order at all. I could have understood the assessing order saying that unless the contrary is proved, be presumed to have been sold within area. I have given them all my sales vouchers, bills, challans, everything. There is not a word, my lord, in the assessment order. Rather, my lord, I will show your lordship one paragraph which says that I will.
So why should we not ask you to secure the amount?
But
What is your answer to that?
But security will come when your lordship finds that prima facie this amount is payable. Here I am taking a
You are
point.
paying nothing, or for
Burdwan area I am paying.
you're paying.
For Burdwan area I have paid for this period.
No.
This is an assessment area.
This is for assessment for which year? This order?
2016.
You are paying.
2016. And that also, my lord, your lordship will see from the act. The rule is every month.
You satisfy us that this new order, which was the subject matter of challenging the writ petition,
yes,
this has quantified your dues to be about 1 crore 7.
That they have taken for 3 years. There is no provision in the act that they can.
You said that you have paid some amount.
I have paid for the local sales within Burdwan area.
But even though it was not with an agricultural produce.
But because till 17 it was, 17 it ultimately went. Otherwise I cannot operate, but without prejudice I have, because there was an order also by the writ court that I shall pay for every month and they will issue certificate. Now what happened? They did not issue certificate for certain months. They failed to issue the certificate for certain months because they were demanding sales beyond Burdwan area. And they started issuing certificate.
Mr. Sen's currently show us that you are paying levy pertaining to that particular your argument we understand.
Yes.
You are urging a jurisdictional issue.
I have prepared a chart, this is already there, my lord. I am showing that for which period they have issued a certificate. একটা copy দাও।
এটা হচ্ছে declaration of sale out of the record, outstanding market out of which SSC only.
But this is because this is not a current demand anyway. This is not a current demand.
This is for the 3 years of 13, 14, 14, 15, 15.
That is also, my lord, under the act. There cannot be assessment for 3 years.
That is we are on the issue of interim order. Now every year you are paying this amount. For this.
Now there is no question of any levy, my lord. These products are not there.
From 2016 you have
17. From
17 you have paid nothing.
No, because it is not in the schedule also.
They raise the demand, you challenge the same. They raise the demand. Your argument before the court was that definition has been altered. I am not required to pay levy at all. That is what you are what we understood.
Yes. After that also, after 2016, there is no demand.
Their demand is also till 16.
There
was no demand after 2016.
No demand at all. So after 30th of April 2016, there was no demand.
30th of
April 2016. This is the last return period which we have filed and payment was made on the basis of local sale.
Where do we find that paper?
এই ডকুমেন্টটা কোথায় আছে বলুন? না এই ডকুমেন্টটা কোথায় আছে? সার্টিফিকেট। My lord, if your lordship sees, I'll show your lordship the page number 149, 758. 149 তো?
Yes.
এই পেজগুলো পেজ নাম্বার দেখো 149. Just kindly give one minute. No, these pages are not.
Yes, Mr. Sen, all right.
Yes.
My lord, I was, my lord, under the impression that today, my lord, who had failed from your lordship on the last occasion, that my lord, almost, my lord, directed me to come with a, my lord, that what is the total, my lord, the outstanding. under these act. Now, my lord, that is, my lord, ready, that the total outstanding amount of outstanding that has been by letter of dated 23rd of June, after the writ petitions are disposed of, my lord, they were directed to pay. Now, my lord, this figure, it shows that there are, my lord, the two periods. One period is from, my lord, that is the subject matter of the writ petition, that is up to 2016. Because initially they, my lord, started to pay, but they stopped. Now, my lord, that is, my lord, the demand raised for that period, which is the subject matter, where the assessment order has been challenged. Now, my lord, assessment order, it appears that 1 crore 74 lakhs and odd was due and payable.
That
Now, my
was
lord,
in the
yes,
previous assessment
previous
order.
assessment order, original assessment order, then it was challenged before the writ court. Writ court said, very good, we are setting aside the same, but again, assess the same after giving an opportunity of them to file their documents, because it was on the basis of our best judgment, since they did not cooperate. According to the,
Mr. Sen,
I am coming to Lordship, kindly, my lord, he said, my lord, more than half an hour, kindly give me 10 minutes time.
We will give you 2 hours.
Now, Lordship, kindly consider. Now, Wala, I am very grateful to your
But we
Lordship.
have only 15 minutes.
My Lord, Lordship, kindly consider. I am showing you everything. But only to
one
it's
question.
my lord, may I tell? It's a prelude. Lordship, kindly consider on my behalf. It's a prelude. Lordship, kindly consider. My lord, the act says that, my lord, a regulatory marketing, my lord, zone should be established. It was established. The act says that after establishment of regulatory marketing zone, then the marketing committee should be there. It was there. Then the act says under section 13 that whoever deals with in their business of trade, selling, storing, everything with regard to this type of specified items. The specified items with regard to trading means not only the schedule annexed to the book, through the act. The act says that power has been given to the, my lord, the authority to issue notification time to time.
We are asking the amount.
Now, my lord, this is the, my lord, kindly have a look. This was the demand. Then, my lord, original 1 crore 74 and subsequent period.
This
এটা তোমার
was
client-কে
the
দেওয়া হয়ে গেছে
assessment
already.
of out.
23rd of June.
This is 23rd of June.
Yes.
Yesterday.
23rd June. Now. Please. এদিকে একটু মাইন্ড আমি ডিমান্ড সিস্টেম ট্রাই করলাম, মেন বি মে নট বি।
তাহলে ওকে ইয়ে করতে বলবো, এটা রেকর্ডে আনতে বলবো।
Now, my lord, kindly have a look.
Alright,
When
then
this
Mr.
first
Mr.
assessment,
Sen, you bring it on record by filing an opposition, we will consider.
I am coming to this, but before that, Lordship, kindly consider, they have suppressed this. They have suppressed this today at least. That, my lord, that length of argument did not contain this, that the order was passed by the learned single judge. When the matter was first filed, Lordship, kindly have a look. They were directed to, no,
we are in your favor.
but they were directed to pay the amount first. They did not. Lordship, kindly have a look. Lordship, kindly have a look. This was the order passed by the learned single judge when the writ petition was first filed. That interim order of stay, only this condition precedent. You pay this. They did not pay this. Then a contempt petition was filed. Contempt is still pending. They did not pay. Then they, my lord, brought that amendment. And my lord, on the verge of, my lord, after final hearing, the court say, very good. Now you please do not take any further step. But this was the order passed. Pay this amount first, assessment. They did not pay. At least to that amount.
4 and 5.
But not this
Now, my lord, they preferred an appeal against this. Against this order of the learned single judge, they preferred an appeal, intra-court appeal. Then they.
Now, this is an writ petition challenging an order of 16th May 2019.
My lord, 16th, kindly consider. Yes, and the order passed therein.
Oh, acha. This is subsequent to the filing of those two writ petitions pertaining to 2016 order.
Yes, yes.
So
that is my lord, the subject matter here.
Do you have this order of 16th May?
So that is the appellate authority.
Yes.
Oh, acha.
Yes.
That is the subject matter of this
the appellate authority order challenging the order of 2016. 16.
Yes.
Acha, very good.
The assessment order which I showed your lordship, that has been challenged before us in the appellate authority. Appellate authority by one line has affirmed the assessing authority's order.
Not one line.
Whatever it is, both
it is an order,
But
more than
Mr.
6
Sen,
pages. Why do
the-
you say one line order?
The direction you will pay half of the amount.
But that is a condition for stay. I did not enjoy the stay during the pendency.
Then
of the
how,
writ petition.
then how can you now have your right to enjoy?
This order remains.
Lord,
Mr. Sen.
thereafter, my lord, when they wanted to enforce this demand under Bengal public, then it was stayed. Then the Justice Chattopadhyay was pleased to stay it.
And there is no appeal taken by them.
There was no appeal.
Just who stayed it?
Justice Rai Chattopadhyay. Whose impugned order is this?
This order of
The demand.
28 June.
No, my lord, thereafter, my lord, when the writ petition was finally heard and it was pending, then they initiated a demand under Bengal public demand recovery.
So
that was stayed by the
this
writ
is-
court.
This is
The
the
present appeal has.
part of the record of the proceedings.
You bring it on record later.
I shall. But my lord, kindly do not pass any, my lord, interim order of stay.
We
Lordship,
will
kindly-
pass an order. It is for you to see whether it is interim order or final.
Lordship, kindly see
Following
their
on
conduct.
instruction.
Kindly see their conduct.
When they enforce, it was state.
Kindly consider their conduct.
I could not comply.
My lord, how?
প্রথমে দেবাংশু বসা বললো সিকিউর ডিপোজিট 50%. We did not. They proceeded, then it was state. We got an interim.
They
Well,
waived-
Lordship, you kindly see
they-
page
they
273
waived
where
their
the
right
stay
to
is there.
have enjoy any order of stay. They waived
This
their
was
right.
the demand, the coercive measure
The
taken
court
has been
passed an
stayed.
order. All right. Stay,
Kindly have a
conditional
look at
stay.
page 273.
They did not
Mr.
apply
Sen,
the condition.
we are asking him to bring this. You give a short reply to this, we will consider it.
73.
273.
759.
Sorry, my lord, 759. That is the other appeal. I'll show you lordship from here.
The hard Mr. Sen.
এই এখান থেকে দেখুন।
Done it.
এখানে কত আছে বল?
আমি দিয়ে দিয়েছি।
The main thing, my lord.
Mr. Banerjee, if you want to file, you file.
They are the main.
Yes.
They are the main.
Main is the state যার exchequer
Mr. Chattopadhyay, let the affidavit come. It is a question of interim order, whether we will ask them to secure the amount or pass an unconditional order. That is true.
You are the regulatory committee.
So you also file an affidavit.
The last commission, we have taken a hearing and claimed that.
আচ্ছা তাহলে ওটা লিখে দাও, Mr. Amol Sen, learned AGP, appearing for the state, and Mr. Chattopadhyay, learned advocate. উনিও তো AGP. You are also AGP না? Chattopadhyay AGP না? You are also AGP na? Appearing for the respondent number
4, 5, and 6.
4, 5, and 6.
I appear for the respondent number 3.
Take your lordships kindly.
That is West Bengal State Marketing Board.
Yes, marketing board.
What not I appear?
Appearing for the appearance. Mr. Banerjee, learned advocate, enters appear.
Day before yesterday or yesterday, that demand that Mr. Sen has handed over. Not till 23rd July, they have raised this demand. This demand has been raised now.
Yes,
Very well. Your lordship is in CC of the matter. So
yes, we know we are. Hey, take back your book and yes.
My lord, item number 6, my lord, I am for the appellant, my lord.
Respondent reputation.
My lord, a short question of law is involved here. Because, my lord, the impugned order was passed, my lord. It is also, I have stated in my appeal also, it was passed without
You are
giving.
from the bank.
No, I am for the bank appellant.
Oh, bank has come.
Come.
Oh. Yes, tell us.
But I don't think my reputation was allowed. Our account was declared as a fraud. That classification of fraud has been set aside. There's possibly no scope for an interim order. My lordship will set the appeal down for hearing on any day. Will come back and trouble this court.
My lord,
That my learned friend also agrees.
yes, my lord. My lord may also fix a date and for hearing, if my lord is permitting, admitting the appeal.
Then
What is Can 1?
What is can 1? Any section 5?
No, no, my lord, there is no section 5. It is for passing appropriate order.
Upon hearing the learned affidavit of service. Yes. Yes, item number. Yes, who is in 7?
Item number 7 and 8.
7 and 8.
7 and 8.
Yes, because my lord, the 2 appeals has been filed. Item number 7 and 1 only appeal. Item number 8, I have filed an application. There you go. My lord, your lordship first take item number 7. Yes, item number.
What you are saying?
I am saying
From 2 orders, 2
From
appeals paper, 1 memo of appeal has been filed. There are
2
no
memo of
appeals
appearance,
in
2
the
memo
second
has
one,
been filed.
Memo and
Say in
both filed.
respect of the second appeal. My lord, I am leaded by Mr. Surojit Nath Mitra, Senior Counsel, but he is coming. My lord, I am starting.
Writ petition dismissed as infructuous.
One, in one matter.
First matter. On the grounds, your lordship kindly see the first paragraph. In view of the order passed in court on 9th June 2025 in WPA number 11220. Yes.
Then come tomorrow. Where is Mr.
No, my lord, he is coming, my lord.
This way we cannot.
My lord, second application, lordship kindly take up. My lord, this, my lord, kindly take up this matter.
Tomorrow you come. Ask him to be here. Yes. Where is Mr. Mitra?
Well, he is coming, my lord. He is coming, my lord.
Then you
I start, my lord.
আসো এটা দাও সেকেন্ড ম্যাটারটা দাও Mr. Basu, you are appearing for
West Bengal Financial Corporation.
But the effective response.
Oh, আচ্ছা আচ্ছা ফিনান্স আচ্ছা Where is the order passed?
In the memo, your lordship will find
There are two writ petitions.
Two writ petitions. One is of 2020.
One writ petition was acha, let us see.
While you peruse the subsequent one, then lordship will find the effect of that order. না না আমি আইনটা দেখছি দেখিনি দেখো না ওটা দেখি নেবে না
Yes, Mr.
My lord, may I?
Before he starts, my lord, I must confess, my lord, there is a wrong recording, but I make a wrong statement. The recording is that the subsequent who is bidded, he is tribal. He is not tribal, he is scheduled caste. But nothing turns on it, that I will. On instruction I have submitted, but we subsequently we gather from the auctioneer that the gentleman who bidding in the process, he is a scheduled tribe.
So 25th June is the date for depositing the amount set by the Ransil.
Matching the bid.
May I, my lord? I will not take long, my lord. Admittedly, or I would say undisputedly, my lord, the loan sanctioned was for 40 lakhs. Undisputedly, I say, because, my lord, there is a previous writ petition. There was a previous writ petition in which Direction was given for filing affidavits. They did not file affidavit controverting the statements. Now,
That was pertaining to another sale.
another sale, yes. I shall come to that. I shall come to that.
No, why two writ petitions you have filed?
I shall come to that. Kindly bear with me, my lord, for a few minutes. Sanctioned 40 lakhs. My lord, disbursed 38.6 lakhs.
38.6
lakhs. Now, my client has paid, according to the writ petition, ₹1.5 crores from time to time, not as per the schedule, not as per, my lord, the installment, my lord, schedule. But my lord has paid 1.5 crores again. Till date, my lord, this fact is undisputed. Now, my lord, thereafter, my lord, there was a proposal.
You mortgage what?
I'll tell you, lordship. The loan was obtained for, my lord, furnishing or furbishing, my lord, the hotel building. Hotel building was constructed. Thereafter, my lord, for furnishing the same, the loan was taken. And, my lord, the director of the...
That was in which year? 40 lakhs?
In 1995. Yes. In 1995.
Yes. Writ petition was on affidavits.
No, they did not file affidavit. The earlier writ petition.
What interim order you are wanting?
My lord, not to, my lord, do anything in the meantime. I will tell your lordship why, my lord. I would not have bothered, I would not have troubled your lordship with this, my lord, matter.
Yes.
My lord, there was a one-time settlement, or from time to time, one-time settlement proposals were there. My lord, kindly come to page 85 once. পরিষ্কার কাগজপত্র লাগাও না কেন? পড়া যায় না?
Page 85.
Yes. This document is also there in another place, but equally illegible.
Yes. Page 85, what you are showing?
Yes, my lord. Kindly see, my lord, it is there letter of 22nd June 2018, 7 years back. Kindly come to the penultimate paragraph. However, we would once again request you to pay the balance OTS amount of rupees 15.45 lakhs. This was in 2018. My client could not pay. Thereafter, my lord, from time to time, further proposals were given by my client, my lord, to arrive at a settlement which was not done. Now, my lord, an advertisement was published, my lord. Kindly come to page 99. This is the advertisement which was published, my lord. Kindly come to, my lord, serial number 19. This is the mortgage property. Hotel so-and-so. Not the company, but the asset was to be, my lord, transferred. Then kindly come to the note at the bottom of, my lord, page. Again, my lord, it's extremely difficult to read, at least for me.
This auction sale notice is dated
12th November 2024.
12th November. Oh.
না না বড্ড ছোট ইলিজিবল নয় আমি বলছি না ইলিজিবল বড্ড ছোট Now kindly come to the note. MSTC e-auction number such and such, pre-bid EMD 10% etc. Kindly come to the second line, towards the end of the second line. For property at serial number 19, bids are invited from tribal persons only. Lordship's got it. My lord, this was, my lord, the advertisement. Now it was challenged. It was challenged. Kindly come to, my lord, the order at page 101.
No interim order was granted, will abide by the result. Then what happened?
Yes. Now,
It is still pending.
two things, my lord. Kindly come to page 103 once. 103.
103.
Towards the bottom, my lord, the penultimate paragraph, report in the form of an affidavit be filed by the respondent finance company in this regard within 2 weeks from this date. Page 103, penultimate paragraph.
Yes.
Now kindly turn the page, kindly come to the second paragraph. Steps taken by the respondent shall abide by the final decision in this writ petition. Let the petitioner also make it abundantly clear to the intending bidders in the auction process that they intend to complete the sale only after the finally placed bid is offered for matching to the borrower within 30 days. This was the order. This was the order which was subsisting. Sorry, my lord. Page 104.
Let the petitioners also make it abundantly clear. Petitioners হচ্ছে তো hotel. The intending bidders in the auction process that they intend to complete the sale only after finally placed bid is offered matching to the borrower.
What does this paragraph at 104 mean, Mr. Mitchell? We are unable to.
Page 104.
Let the petitioners.
No.
What is the meaning of this
It's
paragraph?
a wrong recording, my lord. It's the authority, Oops. I cannot do that.
Exactly.
I was the petitioner, I could not do that. And it's a wrong recording.
Yes, then what happened?
Let the petitioner make it abundantly clear to the intending bidders.
Mr. Mitro, can you come back at 2 p.m.? Because we have to rise for a.
Yes, there is something. I was also told by another, my lord. There is administrative.
Just I've been informed that there would be a meeting. So can you people come back at 2 p.m. or we keep it? Can you people come back 2 p.m. or we keep it tomorrow? Is your choice.
No, I will come back at 2 p.m.
All right. Mr. Basu would be there.
If Mr. Basu can come, my lord, I can definitely.
But Mr. Basu's entry was preceding your presence.
আমার ফেভারে
ঠিক আছে That was preferred challenging challenging what, Mr. Mitro? This page 101,
My lord, challenging the earlier advertisement, my lord, at page
page 99.
Lordship.
So we'll abide by deduction for affidavits.
Yes.
But the sale was not stopped.
No.
Notice was not touched.
Steps taken by the respondent shall abide by the final decision in the writ petition.
Then the property which you have
It was
mortgaged
not.
go to them.
It was not. Because there was no, my lord, bidder.
Very good.
Now, they don't file any affidavit. As I have said, my lord, they don't deny, my lord, the positive statements made in my earlier writ petition. Now what they do is, my lord, they come up with a fresh advertisement, which is at page 105. এই বড় solicitor এখানে এসেছে কেন?
কাউন্সিল কে দিয়েছে বলে বিশেষ কিছু আছে না হলে আসার কথা না।
হ্যাঁ
105.
105.
ডেট কোথায় আছে শিখে নিয়েছি। আচ্ছা 2000।
But don't try to read it, my lord. I do not want.
I could only find that at 238, when there was no bidder, the reserve price was raised to 268 now.
Yes.
At 238, there was no bidder.
No.
So they raised it to 268.
And kindly come to the note at the bottom. The stipulation given in the earlier bid was not included. That, my lord, the lordships are aware, my lord, that these properties, my lord, belong to, my lord, the tribal people. It cannot be sold to somebody else. That, my lord, the condition which is at page 99.
Is this the same property where the hotel is situated?
Yes.
Why you are saying it's a tribal property?
Kindly come to page 99, my lord.
Yes.
99 at the bottom notes, my lord. Second line I showed for property at serial number 19.
Will be invited from tribal person.
That's true.
Why,
That-
why this condition? Because
This is, my lord, the property of tribal, and my lord, there is restriction, my lord, that, my lord, tribal properties of tribals cannot be sold to
The
others.
hotel is run on lease, or is it owned by?
পাচ্ছি না কেন?
Is the hotel run on lease, or is it owned by tribal people?
It's owned by the directors, my lord.
Owned by the directors,
The property is owned by the directors.
and they
For
are tribals.
directors of this hotel.
Company.
Directors-
Hotel is run by a company. The property is, my lord, owned by,
The directors, they've given on lease to the company.
it's their internal arrangement, but, my lord, it's running there. And it was mortgaged by the directors. Now, this was, my lord, again challenged. That is, my lord, the order impugned, my lord, at page 222. Or if your lordships are pleased to look into the memorandum, my lord, possibly it becomes easier. Whatever, either of. Now, my lord, kindly come to the order impugned. Paragraph 2-3, my lord, kindly omit. The petitioners are aggrieved by the steps taken by WBFC. Kindly come to the second page. Paragraph number 6. Paragraph 5 speaks of the, my lord, further publication, which I have shown. Paragraph 6. During the pendency of the writ petition, the corporation, by a notice dated 23rd May 2025, has intimated the petitioner to pay the sum of rupees such and such together with further interest and other dues within 30 days from the date of the notice, and on receipt of the amount, the corporation shall release the mortgage and hypothecation charges on the secured asset. The notice further mentioned that in the event the petitioner fails or neglects to pay the entire outstanding dues, the corporation shall proceed to sell the entire fixed assets, including land, building, etc. Now, kindly come to this notice. Now, kindly come to page 227. Kindly come to page 227. Lordship's got it. You are aware that a term loan of rupees 40 lakhs was availed of by you from the corporation during the period 31st March 2009 to 27 January 2010. Because, my lord, though it was, my lord, applied in, I said, 1995, but the, my lord, money was released during this period for setting up a hotel at such and such, under certain terms and conditions as laid down in the loan agreement made and executed by you, etc. Kindly come to the next paragraph. It is hereby informed that despite allowing several opportunities for regularization and liquidation of the loan account, you failed to do the same, and the account took an alarming shape, and you are still is liable to kindly take note of the next. You are still in a liability of rupees 1 lakh towards principal and 87 crore 85 lakhs towards interest. হ্যাঁ, না দিলে তাই হবে। ইন্টারেস্টের রেটটা কি কেবল সেটা বুঝতে পারলাম না। অনেকটা। Now, my lord, 1 lakh principal, 1 lakh 215 is the principal, and my lord, 87 crore 85 lakh is the interest. And this my client receives, my lord, after filing of the writ petition, because, my lord, I could hear the, my lord, whisper that, have you challenged this? No, I could not, because I did not get any opportunity to challenge this. Now, I'll show your lordship their chart, their interest chart. Kindly come to page 98 once. the interest charge of WBFC.
No, Mr. Mitro,
Yes, ma'am.
when you challenge the earlier sale notice,
Yes.
in that you did not get an interim order, only to the aspect that it will abide by,
Yes.
subject to a condition that you would be allowed to match the price.
Yes, very well.
So that situation was accepted by you. You did not prefer appeal against that order. However, it subsequently became infractious.
Yes.
Then why, on the same argument, Mr. Mitro, we shall restrain the authority?
It does not speak of three things, my lord, with respect. Number one, my lord, it does not speak of, my lord, the fact that it's a tribal property. Though, my lord,
that condition allowed.
Mr. Bose was, my lord, misled by his client to say that, my lord, the offerer is a tribal.
That is not so.
That is not so. That was number one. Number two, my lord, the order provided, my lord, that it would be indicated to, my lord, the intending purchasers that, my lord, it has to be indicated to the intending purchasers that, my lord, I would be entitled to match. That is not there in the, my lord, advertisement.
No, that was the order, Mr. Mitro. Page
That is,
103.
nobody speaks of the order. The advertisement ought to have spoken of the order. With respect, my lord, the advertisement ought to have spoken of, my lord, the pendency of the writ petition. Nothing is there. Now today, I'm forgetting all this, my lord. I'm forgetting all this. Now, my lord, they say, my lord, principal amount is 1 lakh of rupees. My lord, with reasonable interest, I am, my lord, willing to deposit. On 1 lakh of rupees, my lord, they say 40 lakhs of rupees was the loan sanctioned in 2007 to 2009. So, my lord, 17 years. My lord, kindly calculate interest at the rate of 15% on, my lord, 40 lakhs of rupees. That comes to 6 lakhs per year. Now, 6 lakhs per year, my lord, 17 years, my lord, it comes to, my lord, it cannot come to, my lord, 87 crores. And, my lord, the principal amount has come down, admittedly, it's their document. No, my lord, they, with greatest of respect,
Principal amount has come down. Oh,
they say in their letter, they say it's 1 lakh.
Now, and your other contention is that they cannot give it to non-tribal.
No, it cannot.
Now,
My lord,
when is when is the last date for
tomorrow, my lord, in terms of the order?
Mention that the consideration amount has to be paid. Consideration amount has to be paid. What is that consideration amount?
87 crore. And my lord, one further submission, my lord. Interestingly, the document at page 227.
Mr. Mitro, will you place paragraph 16? We do not. What is the direction? 224. 224 order portion, page 6, paragraph 16.
The corrigendum notice dated 27th May 2025 was published by the corporation, mentioning that the consideration amount has to be paid by 25th June.
Yes. Now,
the corporation shall follow the date as mentioned in the corrigendum notice dated 27th May 2025 and permit the petitioner time till 25th June 2025 to match up the bid or to pay the due amount.
So you have not been asked to deposit that amount on 25th June. This what is the meaning of this paragraph? That the mentioning that consideration amount has to be paid by 25th June. Corporation shall follow the date as mentioned. What does it mean? That you have to pay that 87 crores by 27th May?
That is what I read, ma'am.
So you have to deposit 87 crores by 27th May, and thereafter you have to match the bid, if any, furnished by the.
Match to that is the matching amount.
87 crores.
দিয়ে দেয় where's the question of
তাহলে what
selling
is,
the property?
how do you construct paragraph
না
6?
paragraph আমার যেটা মনে হয়
I proceed on the basis that 87 crore.
it can't be. If you deposit 87 crores, then the question of selling the property can't arise.
So, to stop it.
So therefore, this paragraph seems to be a bit
It is a bit
confusing. See, once you pay, then where's the question of matching? Then
নিচ্ছিলেন
where is this
27th May is
addendum notice of 27th May?
27th May is just after that, my lord. I was placing 227.
30.
Kindly come to immediately thereafter, my lord, at page 230.
One.
না না এটা হচ্ছে এই better the offer of 268 and submit the same along with the payment of entire consideration. Any other interested buyer?
না না alternatively তার মানে তো টাকা দিতে হবে না alternate corporation dealing with the sale gives you an offer equivalent to or better than that of
268 interested buyer
from এটা মানেটা কি ও বায়ার ধরে নিয়ে
buyer ধরে আনবে
সে যদি এই টাকায় দিয়ে দেয়
তার আগে ওকে 268 জমা করতে হবে বায়ার এসে অ্যামাউন্ট যদি একটা কোট করে 268 ম্যাচিং
না এখানে অল্টারনেটিভলি যেটা আসছে না বলছে 268 from any other interested buyer of your choice and submit the same along with down payment of entire service within 30 days. In such case,
I had shown your lordship's my lord, page 98. Their interest chart. The maximum rate of interest, my lord, mentioned is 10.50%. Now, my lord, 87 crores, my lord, with greatest of respect, my lord, I tried to
10 হচ্ছে 4 লাখ টাকা
make a back calculation, I could not.
60 কোটি কম্পাউন্ড করে ধরি তাহলেও 3 কোটি 5 কোটি ধরে নিচ্ছি 87 ক্রোসটা কি করে আসে বছর 40 বছর 95 থেকে 10.5 ধরছি ট্রাস্টিক এটা 10.5 বা 10
পেনাল্টি আছে 2%.
10% করে হলে 4 লাখ
it is not, my lord, a offer from a tribal people.
Nothing
If that
turns
is
on.
not done,
That is
it
turns
does. It does, my lord. The
Let me-
property cannot be sold.
Let me.
The property cannot be
Just one other question. Paragraph 11 of the impugned order. Is this correct?
Which one? Take up. 11.
Paragraph 11 of the
Subject property being the secure assets was put. Yes, secure assets. Mortgage
Get
property.
relinquished his right.
No, 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 no. No.
That's what I
Sorry,
wanted.
yes.
I wanted
No.
to know this.
Subject property being secured was put to mortgage by the company. No. It was by the directors.
Says being the secured asset was put up. No, read the whole thing, Mr. Mitchell.
Yes.
Was
May I?
put to
The
mortgage.
subject property being the secured asset was put to mortgage by the company in whose favor the tribals had executed. No.
This portion I'm worried
No,
about.
I took specific instruction. The mortgage was created by the directors. The property stands in the name of the directors. I took specific instruction.
So the deed of relinquishment.
I have.
Oh.
What is his contention about if I understood correctly? First of all, one of the he was very for us so far as the quantum today. But there is no challenge in the writ petition that the calculation of interest is erroneous. And even if that is there, my lord, except by a suit court, my lord, writ court, by humble submission cannot go into this question. Agreed amount 15% is the rate of interest, 2% is the penalty, and cumulative effect. It looks very weird, my lord. If you also see 1 lakhs is the due, but that you have agreed upon. If something is agreed upon, can the writ court say no, 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 no? You should not act on the terms of the agreed document. Something else.
Which was agreed upon, Mr.
The rate of interest.
Eh?
Rate of interest. Now it looks very weird. I say, appearing for the authority, my lord, I cannot shut my eyes. It looks 1 lakh is the due and 87 crores is the interest. But what can be done?
So what was your interest rate?
15% interest, 2% penal, and cumulative effect.
Where do you get that?
The agreement. Nobody has challenged that. In the writ petition, I have tried in vain to find out any challenge.
So this company mortgaged the property?
By deposit of title deed, and title deed is in name of the company. If it is said today, my lord, the tribal property is now cannot be sold, then I should say, my lord, they have practiced fraud on the corporation by producing a mortgage deed which is name in the directors, not in the name of the company. Now, my lord, I must speak. This is the point, my lord, kindly see this. It was produced before the honorable single judge.
So, Mr. Basu, if you auction the said property, are you expecting that you would be getting 87 crores for that?
No, because thereafter I will get 2,165. 2 crore 68, I am the offer. I'll
That
sell
is
it.
the reserve price.
If he, no, not reserve price. The bid price is 268. One offer is there.
One offer is there.
If he can match 268, property is sold to him. Rest under the Financial Corporation Act, I can proceed against him. Thus the law is clear.
So if the price which you have obtained is 2 crore 68 lakhs for the property.
If he match,
if he matches that.
him.
Now who is the intending purchaser?
Purchaser, my lord, one scheduled tribe person. Scheduled caste. Scheduled caste.
Scheduled customers.
Initially, my instruction was wrong, my lord, because MSTC is auctioning, not us. We have given a NC to the MSTC who will auction.
Oh,
our information was incorrect, my lord. I must be candid before my lord. It is scheduled tribe, scheduled caste.
Then why this exclusion of this rider? Why did you do?
Should I say in open court? Well, this is called sorcerer mode. transferred to in favor of the company upon payment of full stamp duty.
Where is the relinquishment deed?
Oh, I have said just now.
There is not a deed. Oh, deed of release.
Yes. Can you see the turn?
So the property was in the name of the company.
Company that has been mortgaged.
So that has been, no, what is the meaning of this?
No,
The
kindly come
subject
to-
property was paragraph 11, page 224.
Yes.
Subject property being the secured asset was put up to mortgage by the company.
By the company, right? Writ petitioner before my lord.
So they put up to mortgage by the company in whose favor the tribals.
But can it be a character of tribal? Even if can you see this deed? Well, can you forget for the timing language is therein?
Subject property was put up to mortgage by the company.
Company mortgage it by production of title deed.
Up to mortgage করলো tribal no. In whose favor tribals had executed.
Tribals হচ্ছে director, owners of the company. Tribal directors, owners of the company had reduced it in favor of the company. And company then mortgaged in favor of the bank.
Relinquishment deedটা কোন সালে? 95 সালে।
95 exactly ওই ডেটে। এটা করা হয়েছে ম্যাচ করো।
Yes, sir, you match that 2,68,000 finished.
My lord has seen the delinquishment deed.
You match that amount. Match that amount.
Pay.
Then
Second paragraph.
What do you lost?
And otherwise we could not get it mortgage.
So you have Mr.
If they were the guarantors,
That is separate thing. Guarantor. This is
I think-
company itself mortgage, not the guarantor.
but I'm sure there
What?
must. I'm sure there must have been guarantors for such a big
But
amount.
maybe.
40 lakhs in those
But-
days was a lot of
but-
money.
But my lord, this document which was
Oh, correct. You're right.
mortgage deed by production of deed, this document was produced. So here, my lord, company is mortgaging, not the director, not the directors.
You match that 268.
I mean, only one aspect, Malad, this. Perhaps my learned friends, what my learned friend is saying, Malad, on instruction that has been, Malad, submitted that this property is still. Only your lordship is still in the name, Malad. Though the documents are
No,
not
we
annexed.
will not go into the dispute question.
So, Malad,
Suppose your challenge before us, is that see they have for an amount of 40 lakhs today we are being forced to pay an amount of 87 crores. They are saying REIT court granted you liberty to match the price. So they are saying 2 crores 68. You match the price, property goes to you, your loan gets.
So far as that part is concerned, apart from that, your lordship kindly.
No, apart from that, we will
Apart from
hear.
that, 1 lakhs, Malad, 1 lakhs is the principal, according to them. Malad, that is recorded.
1995.
Malad, sorry, Malad, your lordship kindly take out this, Malad, the date. As on, Malad, your lordship kindly see. Not in 1995. The principal, which Malad, they referred in their notice.
I say still that is the principle.
For page 227.
Yeah.
Sir, you come with the instruction. We will dispose of the appeal.
I could understand what he is saying.
Well, the only thing that if it is 1 lakh,
And
is the
we
principal,
will-
I am not on that.
No, you protect your property, sir. Give 2 crores. As regards the dispute pertaining to that, if your 40 lakhs claim is being settled in 2 crores 68 after 20 years.
No, not settled.
No,
my
no,
lord.
no.
Well, it is not settled.
But that
It's not settled. He can save his property by putting 268. Balance, I have a right under the statute to proceed against him.
that your lordship kindly see. That one aspect. Other my lord, your lordship kindly come to my lord that page where my
That
lord,
we will consider. 2 crores 68 you deposit.
only another aspect. My lord, when my
That
lord,
we will consider. You come
only
and file
one
evidence and tell us.
that my lord,
Sir, please, I think we have not made ourselves clear. 2,68,000 if you pay today, still there will be an outstanding claim according to them of an amount of 85 crores.
Around
We will hear the appeal. We will hear the appeal.
Protect your property first.
You protect your property. We will hear the appeal, and thereafter, if disputed, don't have to go to the civil court also for this. We will be insisting of the matter.
Then only I
know. You are covered by DRT.
No. No, well, that is not covered by DRT.
Let's recovery.
There are decisions.
Recovery of debts due to banks and other financial institutions. Section 90.
Self-content code.
Come with the instruction.
Tomorrow
What is the date?
Oh, tomorrow is the
that, my lord, that one. It is because I have to take, even assuming, my lord, I have to take instruction.
Tomorrow is the date for what,
For matching the price under the statute.
Last date. That's why I mentioned.
For matching the price.
25th
That is the last
June.
under the statute.
Last date.
You agree to it, we will think about the date. Agree to it. Come tomorrow, or you tell today, we pass the order, finish.
No, I have to take instruction, from the.
You should have taken that instruction before.
No, that because not that. The other parts is there.
Only problem
That was
if tomorrow
only your lordship.
The other bidder may.
He because of
This is intention.
This is no.
Again, I have to.
No. I am not on that. I am not on that. Only thing.
Owned by him ultimately. It will increase again.
Your lordship.
It's a problem. Further complexities may arise.
No, that's why my lord, this I am not on that. The
If you are not on that,
auction,
then
yes,
there
the auction. I am not on that. The 25th. If I fail, then this auction. If I take the time and in that event the new auction has to float it. That is not there. Your lordship state the auction itself for a period of 7 days, so that in the meantime, if I take instruction and 7 days means on Monday. Today is a Monday. I
will go.
Come
back. That cannot be, because this is not the. Your lordship kindly.
Sir, how can we help you? We were not litigating. You were litigating for your clients for a substantial period of time. Sir, you also very well know that the court will be insisting that now you deposit that, then we will consider.
At least, 2-3 days to be taken.
Come at 4 p.m. sir, with the instruction.
Tomorrow.
4 p.m.
Today. Kindly, your lordship has admitted that tomorrow can be. But tomorrow, kindly, tomorrow at least, tomorrow.
Give a phone call to your.
That only take time, whether by tomorrow they can.
We will not extend the date.
By tomorrow they
then
can.
You come with the.
Only tomorrow. I am not asking more this. Tomorrow is the last date. Then tomorrow at least.
Twenty-seventh May.
30 days.
That has been affirmed by the court.
30 days. 27th June, 30 days. It's not like
24th June. That's it.
Okay. June was, May was 30 days from the date of this letter. That is 25th June মেনশন করে দিয়েছে, মেনশন করে tax which has been mentioned there. That amount you secure, we will hear the appeal.
My lord, on the basis of an offer by a person who had no authority to, my lord, make the offer. If they, my lord, had mentioned in the advertisement that, my lord, it is restricted to, my lord, tribals only.
No, but that, Mr. Mitro, there's a deed which Mr. Basu has produced.
Relinquishment deed
It's a
is
deed of relinquishment.
that is referred to in paragraph.
Mr. Basu, give him a copy.
This property has been
Mr. Sarkar sitting there for 2 hours not giving him a copy.
দেয়নি কপি দেয়নি
No copy has
আরে
been
কপি দাও
No copy has been
আরে কি মুশকিল
বি সরকার আছে না কি করে কপি দেবে?
ও এটা কি আরে দাঁড়াও দাঁড়াও
What is the date of the loan? Loan 19. No, 95. I want the date.
It was disbursement was of 2009 10.
23rd November 19.
And this release deed is of 27th November. This deed of release is of 27th November 1995. That's why I asked.
Sanction, then mortgage, then release.
It could have been done by the directors themselves as guarantors.
No, this is not a guarantee.
Trying to understand why was the property released in favor of the company by the directors.
Now the company's properties would have been mortgaged.
Why? That's what-
Can you see the language used there?
The Darjeeling? Darjeeling.
স্পেসিফিক্যালি জিজ্ঞেস করেছিলেন এই কথাটা
প্রপার্টি কোম্পানির নামে mortgage করলো company।
তার আগে ডিড অফ রিলিজ করে ডিরেক্টররা রিলিজ করে দিল ওদের প্রপার্টিটা ইন ফেভার অফ দ্য কোম্পানি। সেটার জন্য 5,000 শেয়ার পেল ইন ডিউ অফ দ্যাট রিলিজ।
এই রাইটটা ট্রাইবালসরা রিলিংকুইশ করে করলো
কোম্পানি মর্গেজ করে।
হ্যাঁ কোম্পানি এবার mortgage করে। Yes,
on this document, my lord, I have to take instructions, but this much I can say. Relinquishment, my lord, can happen between, my lord, two co-owners. I cannot give, my lord, by way of relinquishment, my lord, I cannot give property to, my lord, somebody else.
This is almost like a sale.
Then, my lord, it's an no 50 rupees.
Because the stamp duty is not paid.
50 rupees.
Insufficiently stamped.
Sufficiently stamped.
Insufficiently stamped.
No, there are other documents to show the stamp.
has to be on this stamp.
It has to be on this document.
How can there be another document for stamp?
Can my lord company say this? I'm asking the question today. I'm not going to that controversy. Company itself produced this document and mortgage the property. Now they are saying this is not my property. There is
Mortgage the property. Property was mortgaged by the guarantors.
Yes, that's what. Who was the guarantor? That's what I wanted to know.
Yes.
Mr. Basu says there's no guarantor. It's very improbable in this sort of a transaction.
Guarantor may be there, but I kindly
Show me who's the guarantor. Let's see who has mortgaged the property.
property mortgage by the company.
Show us the document.
This is the fellow kindly come to the note. Page 44, kindly see the
40?
44. What has been secured? You see who it is addressed to? The loanee, the petitioner before my lord. And kindly see the thereafter, after the dotted line.
Well, that does not mean, my lord, that the property did not belong to the guarantors, and there is provision of, my lord, guarantee.
No, there is. Come to page 49.
Yes, I saw that.
Where's the mortgage deed?
It's in their custody.
No mortgage deed. By production of this deed, mortgage was created.
No, there has to be a document. By deposit of title deed,
Deposit of title.
then, my lord, there has to be a document to that effect.
Yes, there has to be a deed of mortgage, Mr. Vasu.
That is on record. We have not filed affidavit. So that's why that is not there. But this document suggests that the property belongs to a company. And by showing that, they opted loan. My lord will encourage if it is practiced for wrongly given. To take an advantage of his own wrong.
So Mr. Mitra come with that instruction. We have asked him to take instruction as regards your as to whether you can deposit this amount.
2 crores or not, I don't think, my lord, they would be in a position. But I will take instruction again.
In that case, how do we help you, Mr. Mitra? Because after we stay for us 7 days, you come and tell us that we are not, you will hear it on merit. By that time, by that time the date expires. Other multifarious things may arise.
My lord, if I may ask myself the question, when they, my lord, published the first advertisement, my lord, a few months back with the note that, my lord, it has to be to tribals only.
How this clause can be removed?
And with that clause, they did not get the offer. Today, my lord, the offer.
Getting an offer. But this relinquishment, what do you say, Mr.
The other relinquishment, it could not have been, my lord. I can show, my lord, I can come up with cases, my lord, relinquishment can happen. If I have a right, I can relinquish it in favor of another person who has also right. 2 co-owners, my lord, one can relinquish.
This is the mouth of the petitioner. This is the document they produce. Then I repeat, one is the practice fraud.
Your advocate on record was praying for time so that he can. But if this is the instruction that you will not be able to.
I will take instruction, my lord. I thought, my lord, that was the financial position.
Heard the learned advocates appearing for the respective parties.
Item number 9.
I'm for the appellant.
My lord, I am for the private respondent, my lord. On the last occasion, your lordship desired me to take necessary instruction whether the, my lord, kindly remember that nano car parked in the narrow road.
Yes, yes, yes.
My lord, I have taken instruction, my lord. My lord, the appellant kindly come to the annexure P2 that the child for whom the car used to park in front of the car is a plastic child.
Show us the.
Yes, ma'am. My lord, kindly come to page 37 of their
37.
application. My lord,
37, your lordship.
37. My lord, I have taken instruction. My lord, I would like to place some video. The boy, he is riding cycle. He used to drive the car, and he is a school. He is a student of BCom in St. Xavier's College, my lord. Regularly going. My lord, if your lordship allow me, so I can give you the. I can show your lordship the CCTV footage.
এই করে বেড়াই আর কি। কে হ্যান্ডিক্যাপ আমরা বুঝে পাই।
Spastic paraplegic.
My lord, kindly state is not here. My lord, kindly produce. Is it? State. My lord, state is here.
You already have a garage.
No, your lordship.
Yes.
You don't.
No,
You
no.
don't have a garage. Then you have brought a car to be parked in the municipal road.
No, your lordship. Your lordship, actually, the point is that why only 2 cars of the appellants are being disturbed? Your lordship, while I have shown your lordship on the
If an
last occasion,
illegality is being perpetrated by others,
Your
you
lordship-
cannot claim parity.
your lordship, let the municipal authorities take steps.
We will say that
But-
if any car is parked in that road,
Yes, but
they
your
would-
lordship, I humbly submit that this is for my emergency purpose. Your lordship, I have annexed.
emergency purpose. That is why we are saying
Your lordship.
you could have, if you could have told us that, sir, we have a garage in the adjoining
Your
premises.
lordship, I have rented a garage, but only at the.
This cannot be ensured by you also.
Your lordship.
Because suppose I have a garage which is say 10 minutes from my residence.
Your lordship.
I will go in the morning and I will bring the car from my garage and park it in the municipal road
Your
for
lordship,
the whole day.
Your lordship, does it gives them authority to vandalize my car after pursuance of this order?
If they no, that is a separate issue.
Your lordship.
You can lodge a complaint to
Your
that
lordship,
effect.
I have, but
So
since
proceed on
Your-
that basis.
but your lordship, ample of representations have been made. Your lordship, kindly see from
that
page
is a
number.
separate cause of action.
Your
We
lordship.
are on this
But after
issue.
pursuance of the order of the honorable single bench, they have vandalized my car. Your lordship. And the police said,
So that is the purpose of the police to go in.
your lordship, but the police says since the matter is pending, appeal is pending, we cannot interfere.
My lord, nothing.
Your lordship,
No.
it is not creating, neither it is creating any nuisance, neither it is obstructing any traffic. Your lordship.
Then how you are allowing other cars to be there in the passage? He cannot park his car. Nobody can use that municipal road.
Lordship, it's a municipal road as per my information.
So
Lordship,
then
narrow,
he is not
narrow
being-
road, Lordship.
So you take steps for removal of the other cars also.
If there is any order, of this honorable court, police is bound to comply, Lordship.
Your Lordship,
Order on
what is
minor
your,
detection, Lordship.
what is your, Your Lordship, this is the condition of this is the present situation, Your Lordship.
মানে রাস্তা পুরো পরিষ্কার থাক, যার যখন গাড়ি আসবে এসে
আপনি থানায় কমপ্লেন করুন, যে
করা
অন্যান্য
হয়েছে,
parking এর
করা হয়েছে,
written
annex আছে।
complaint করুন।
আচ্ছা,
নেই।
আচ্ছা, annex আছে। Even to the district magistrate, I have made this presentation. This is the condition of the present moment, Your Lordship. This is the present. This is the locality, Your Lordship. Where have you said how many cars are parked apart from your car? In your writ petition, have you said so? Your Lordship, I have said other car parks, others are also
No
parking their
particulars
cars.
has
Yes,
been
Your
mentioned,
Lordship.
my.
Your Lordship,
Particulars.
who are you? Who are you?
I am for the respondent number 6, 7, 8, 9 and 10.
So you don't have car.
We have car, my lord.
And
But
where
we
do
have
you
car, our car is parked in our garage.
Where is your garage?
In our residence, my lord.
Oh, I see.
My lord, this is a flat, my lord. They are staying in a second or third story in a building. And that building has only single garage.
So themselves has come.
And my lord, the
Lordship.
State includes the officer in charge, na? Did you file any report before the writ court?
Yes.
Huh? You filed it? Where is that? Can you show us? Did they file any report? Your Lordship, just they have mentioned that this is a municipal road. Where is that? Show us. Your Lordship, I don't have the report. They haven't served. Your Lordship. Your Lordship, page number 53 in the order, Your Lordship, the Honorable Single Bench has mentioned.
my lord, second page of the
Is for the municipality is a party?
Yes, Your Lordship. No, Your Lordship, municipality is not the party.
আসল লোক কি পার্টি করে?
ওকে পার্টি না করে মামলা। আশ্চর্য ব্যাপার।
My lord, they have made the councillor as a party, not the municipality. I am representing the councillor also, my lord.
It's a municipal road.
Yes, my lord.
What is the address of that road?
Address of the road, my lord, 45/10/3 Shashi Bhushan Niyogi Garden Lane. All are resident on the same path.
Though in that municipal road, other cars are also being.
No,
No,
my lord, no.
Who is he?
Not a single car, my lord.
Who is he?
My lord, he is respondent number 9, my lord.
What he is doing here?
My lord, I am taking instruction, my lord.
He has brought the video of that
child who is walking in the lane.
Riding cycle, my lord.
He is
You take instruction and come back to us with a, because I don't know what was report you have got.
Written report is
You ask your OC to come and tell you to give a report that if which are apart from his cars, any other, whether any other car is being parked in that municipal road or not. Huh? You can avail necessary instruction to that effect. Instruction and report will be
kindly, my lord, kindly page 53 order portion, kindly.
53 order
And the
portion.
council appearing on behalf of the state submits as follows.
Yes, very good. They do not have a right. Municipal authorities and the police authorities are to take appropriate steps. Municipality municipality কেও তো পার্টি এখানেও দেখছি না কোনো রিপোর্ট ফাইল করেছে
রিপোর্ট আপনি
পেলে
না ফাইল করেছে কিন্তু
পুলিশে ওসি
And may I say something? Well, let the municipality be added as a party and submit their report also.
Your lordship, I have already made councillor the party. Councillor may give instructions to his learned council, your lordship. If it is a municipal
First
road,
of all, you have no right to park car on
your
that.
lordship.
So don't open your mouth too wide.
Your lordship.
You don't have a genuine claim to evade. We are trying to help out and sort out the problem.
Your lordship.
You first come and file a this. You tell your officer in charge to give a file a report before us whether any other car is being parked in that municipal road or not. Ashok.
Your lordship, may I one submission, your lordship. Let the private respondents be restrained from obstructing.
Then we dismiss your appeal. When you are wanting so much of protection,
no, your lordship,
making false statement before us.
No, your lordship.
You have a handicapped child.
Your lordship, I have filed the
when
report.
The child is riding a bicycle.
Your lordship, in the year 2016, that this report was been filed, your lordship.
The present appeal has been You ascertain whether
Lordship.
your clients are having
Lordship.
this fact is right or not.
Your Lordship.
That you tell your appellate that you told me such and such, court is asking, they are saying all these
Your
things.
Lordship. I will try to file the final report.
Try na, find it out. Yes, next.
6 তারিখ হলে ভালোই হবে, 5 তারিখে ছুটি আছে।
শোনো, তুমি বিচার করতে মাল ছুটি করে দেবে।
দাদা বলছি আমাদের
একদম 3 দিন ফাটিয়ে ফাটাই আমার চয়েস।
Your Lordship has been pleased to grant me an opportunity of taking out a affidavit in opposition. My lord, it is yet to be affirmed, my lord. I'm praying for a week's extension of time for filing the affidavit in opposition to their application. And I am for the respondent. Lord, it is on I could not do, my lord, my personal grounds.
Mr. Banerjee, learned advocate appearing for the writ petitioner. Item 11.
11, I appear for the appellant, my lord.
Yes.
This matter was heard twice on earlier occasion, my lord. To
Who is opposing you, madam?
Mr. Oyon Banerjee was opposing, my lord.
Oyon Banerjee.
And his Rana Junior was, I do not know the name of his Rana Junior, but he was there.
Can you just remind us what is?
Yes, madam. Madam, this matter relates to mutation of a Salt Lake property. Property is situated in Sector 1, measuring of above 4 cutters of land. Above 4 cutters of land. My lord, mutation, this property was purchased by a registered deed. Rather purchased, I will not say, my lord. The leasehold rights of the property was transferred by way of a register. The original lessee of the property was one Gauri, Shudhanshu and Gauri. Thereafter,
You are there.
Yes, madam.
Here for the state.
Yes, madam. I am late by Oyon management.
Why the mask is on your ears?
I am late by Oyon management.
Your mouth has to be safeguarded, not your ears. Yes, yes.
The original lessee of the property was one Shudhanshu and Gauri, which was subsequently transferred to one Pratik, and Pratik has transferred to the present appellate by a registered deed on executed on 30th August 2007. Mutation was applied for and mutation was granted by a letter wherein it was stated that you must pay 2,000 rupees fees, mutation fees, and produce all the original documents, which were done. Then subsequently it was informed that the appellant has to file an affidavit the appellant.
Yeah, just once. When did we hear it, madam?
My lord had heard it, my lord, on 13th May 25 and 19th May 25. The first was 13th May 25, my lord, heard it existing. And then on 19th May, my lord, adjournment was sought by first by the respondents. And then the matter was adjourned 1 week after vacation. Right? Order by anything.
Yes, ma'am. You purchased it from?
The leasehold rights were transferred from Pradeep by registered deed. I applied for mutation and mutation was granted to me in the letter where I was communicated, which is at page 118 of this.
Prior to that, you approached the court for consideration of
No, my lord, that stage is over. Now, what
page
has
93? What is page 93?
my lord, the page 93 is, my lord, the first round, my lord.
That your mutation was not being considered.
Yes, yes. So now, my lord, comes to page 118.
Page 118.
118.
Yes.
12th September 2008. This
Yes. 12 September 2000.
This refers to your letter of 9th October 2007 regarding mutation of plot number such and such in the name of Dinesh Kumar Goyal. The competent authority has approved mutation of the aforesaid leased property in your favor on completion of the necessary formalities and payment of requisite charges. Accordingly, you are requested to deposit rupees 2,000 in the proper head and also to meet the undersigned along with the original document of transfer for proper verification.
Yes.
My lord, the two conditions that are set out in this letter were complied with. Now, subsequently, they have asked the appellant to give an affidavit declaring that he or his wife or his family members do not hold any other property in the Bidhannagar on the KMD area. My dispute, my lord. My question before my lord.
Where is that memo?
My lord?
That you were asked to make
Yes,
that
yes,
declaration?
yes. My lord comes to page 124. That's a communication dated 18 September 2008.
Yes.
The order of the principal secretary approving mutation of plot number such and such in the name of Dinesh Goyal has already been handed over to Dinesh Kumar Goyal by special messenger on 12 September 2008. Sri Goyal contacted the undersigned on 15 September and furnished the original deed of conveyance, which was verified with a Xerox copy of the same. Sri Goyal was advised to deposit the requisite fees of 2,000 in the proper head and also submit an affidavit the pro forma of which is handed over to him. Sri Goel has since produced a copy of the receipted challan of 2000, but not the affidavit, which is to be submitted as per procedure for mutation in the leasehold residential plots of land in Salt Lake area, in receipt of which the mutation can be carried out. So a affidavit was.
Where is he? Call him, call him. You have told him?
Yes, my lord. Today morning, since I am with him, my lord.
Go and make a phone call that we have started this matter. No adjournment. Yes.
My lord, I have challenged.
Then what happened after that?
My lord, I have challenged this in writ petition.
This memo was challenged.
This memo that I am not required to give an affidavit.
Very good. Then what happened?
My lord, then the writ petition was dismissed by an order dated 3rd October, 3rd October 2024.
3rd October 2024. That is page?
Yes, madam. That is at page 17.
17. No, tell us now, what did the court say? Court say no, that is mandatory.
The court said yes, that is mandatory, and that another thing, the court has gone beyond the back, my lord, and conducted an investigation from where it was revealed that the appellant was a co-owner of another property along with his brother. So I was not given.
Inquiry was conducted.
My lord?
In terms of the court's order, an inquiry was conducted.
Yes, the court on its own motion had carried out some verification. I was not given any chance to come out with any objection to the same. My lord, it was there for the first time in the judgment itself.
I see.
In the judgment itself.
Where is that report which was relied upon by the
There
court?
is no report. It is embodied in the judgment itself, my lord.
Yes.
At page 33.
Page 33.
At paragraph 18. On verification of records of this court. My lord, the Honorable Court carried on the verification so motu. It appears that one writ petition being such and such was filed in the High Court by one Mahesh Kumar Goel and Dinesh Kumar Goel, son of late Ram Nivas Goel, stay and praying for mutation in respect of another premises being EC 149. The present case is also the prayer for mutation by the petitioner Dinesh Kumar Goel in respect of plot number EC 134, which prima facie is against the provisions of Urban Land Sealing and Regulations Act 1976, if the property EC 149 still stands in the name of the petitioner.
Just. Now, madam, please come to that paragraph from 15 onwards.
My lord, before that, my lord, which is very essential, is when this letter was challenged in the affidavit in opposition, the respondent said that this affidavit is required pursuant to a policy decision. My lord, the policy decision was handed over in the course of hearing, my lord, which is part of this state petition, of this application of appeal. My lord, that cabinet policy, my lord, reveals that this the restrictions were in respect of plots situated in sector 2 and 3, and in sector 1 plots measuring 2 and 3 kattas of land. My respectful submission before this honorable court is that
not applicable.
This cabinet policy does not cover any plot situated in sector 1 measuring over 4 kattas of land. Malan, may I place the cabinet? So the cabinet policy
does not cover any plot above
4 kattas in sector 1. Primarily, this cabinet policy relates to properties situated in sector 2 and 3.
But it is a fact that you have another, you are a co-owner in respect of another property.
I am a co-share. I mean, after this judgment came out, my lord, I found that he is a co-sharer along with his brother. But even so, my lord, even if I've gone through the cabinet policy thereafter also.
We shall come to that. But madam, will you please place from paragraph
15 as my from my lord.
all right, you proceed in your way. We shall. What is this 16th May 1966? Paragraph 15, they are saying.
By 1966, this document, the document has been relied upon by the respondents in their affidavit in opposition.
I see.
In their affidavits in opposition, well, let me place the document.
This was a declaration given by the original lessee.
The original lessee, my lord, comes to the declaration, which is at page 170. My lord,
page 170. This is 16th May.
My lord, this is
15 July 65.
Yes, 15 July, my lord, and 16th May, my lord, 16th May is at page 173. This is an application. This is a part of the affidavit in opposition. Application accepting offer of allotment of land. In paragraph 1, it is stated that we hereby declare that we do not possess or have any household property or share or interest in any such property within the limits of Calcutta Metropolitan Planning Area. My lord, comes to page 175. At the bottom, it is dated 16th May 1966. But my lord, from the signature, my lord, I am unable to decipher, my lord, which is that this application is relating to the original lessees.
Now the court says about paragraph 17 of your deed of conveyance.
Yes, paragraph 17 of my deed of conveyance, my lord.
That is at page?
Page 83. To observe, perform, and comply with the requisitions as may be made from time to time, be made by the government or any other authority in respect of the demised land or building. Well, this is a part of the deed.
This deed was dated?
This is 30th August 2007. That is between the Pradeep Chandra Sinha and the present appellant.
Pratik was the original lessee?
No, original lessee was Sudhanshu and Gauri.
Yeah, just Sudhanshu and Gauri.
Sudhanshu Ranjan Chakraborty and Srimati Gauri Chakraborty. They were the original lessees. Thereafter, it was transferred to Pradeep Chandra Sinha.
Pradeep Chandra.
Pradeep.
PRATIP.
On 30th November 1984.
Pradeep Chandra
Sinha.
30th
November 1984.
Oh, achha. And you purchased it
from? I purchased in August, 30th August 2007.
That is page 183.
That is, at page 75.
83.
Page 75.
75.
The page 75 is the deed. Page 75 is a deed executed between Pradeep and the present appellant.
Yes. Then comes the cabinet decision of 5th November.
Before that, I would like to place the affidavit in opposition.
Which they filed. Their affidavit.
Their affidavit in opposition.
Ayan Banerjee's affidavit.
Ayan Banerjee's.
Yes.
starts from page 126. My lord, I will only place the relevant portion of the said affidavit. My lord, comes to page 129.
Clause C.
E.
Clause E.
It had been the policy of the government not to allot more than one plot of land in the Salt Lake area to any particular family. Moreover, in the cabinet,
Now, just a moment, madam. Your plot is measuring how many cutters?
4.3 cutters, sir.
4.3 cutters in sector 1.
In sector 1.
Achha.
4.2395 cutters to be exact.
Very good. Now, it had been the policy of the government.
Moreover, in the cabinet, the government decided that a person having more than 2 kata plot of land in Kolkata metropolitan area is not eligible to acquire a plot of land in Salt Lake. Later on, the government from time to time imposed several terms and conditions with a view to restrict any individual or family from acquiring more than one plot of land in the KMD area. The answering respondents crave leave to submit a copy of the policy at the time of hearing. So that policy had been submitted, my lord. In the affidavit in opposition, further, my lord, I would place reliance, I would like to point out paragraph G.
Yes.
That is at page 130.
Yes.
To preserve and to uphold the policy of the government and to comply with the provisions of the Urban Land Ceiling Act, it is expedient on the part of the concerned department to seek declaration on affidavit from the proposed lessee and or the proposed allottee, whether the allottee and or the proposed lessee is holding more than one plot of land in Salt Lake area or not. So it is the case of a proposed allottee or proposed lessee.
Yes.
My lord, I was at page 131. This expedient, may I repeat?
Yes.
It is expedient on the part of the concerned department to seek for a declaration on affidavit from the proposed lessee or the proposed allottee, whether said allottee or the proposed lessee was holding more than one plot of land in Salt Lake area or not, and whether the said allottee and or the proposed lessee is hit by the provisions of Urban Land Sealing Act. So it was the case of the affidavit required in the case of a proposed allottee or a proposed lessee, if at all. Then, my lord.
So you are putting weight to the term proposed to mean that a person in future.
The
but
person
it
in
is
future.
not applicable to you.
If at all.
Yes.
My lord, then.
And where is that condition, that cabinet decision now?
Yes, my lord. I will place that, my lord.
Now you want us to see page 157, paragraph.
My lord.
You placed it on the earlier occasion.
Yes. My lord, page 222, I think it is annexed twice. So page 222, it forms part of the written notes which I submitted before the learned trial court.
No, you come to page 157, you placed this paragraph, I think.
157. My lord, give me a moment. 157.
The answering respondents further.
Yes. The answering respondents further state in this regard that the government of West Bengal in its cabinet meeting decided that a person having more than 2 quarters plot of land in Kolkata metropolitan area is not eligible to acquire a plot in Salt Lake. Moreover, it is necessary for the concerned authorities to determine whether the person acquiring the plot of land in Salt Lake area is being hit by the provisions of the Urban Land Sealing and Regulation Act. It is the usual practice. It is the usual practice of the concerned department to seek a declaration from the concerned allottee in this regard. The answering respondents submit in this regard that the definition of affidavit in the General Clauses Act include declaration. Under the Indian Penal Code, a person can be proceeded against if he furnishes an untrue declaration on oath, that is on affidavit. So, to preserve and or uphold the policy of the government and to comply with the provisions of the Urban Land Sealing Act, it is expedient on the part of the concerned department to seek for a declaration on affidavit from the proposed lessee before mutating his names in the records of the government with regard to any particular leasehold land where the government is a lessor.
In order to give effect to the policy decision,
yes,
they have asked you to file an evidence.
Yes. So everything is based, or the affidavit is required of me on the policy decision.
Yes, that is page 209.
Yes.
Yes.
Page 222 is the policy decision. It's a decision of the cabinet held on 5th November 1979. Subject: eligibility of residential plots in Sector 2 and Sector 3 of Salt Lake Township. The proposal contained in paragraph 6 of the cabinet memo is approved. My lord, thereafter is a typed copy. My lord, comes to page 224. Eligibility for residential plots in Sector 2 and Sector 3 of Salt Lake Township. Page 224, my lord.
220?
Page 225 is a typed copy. 224.
This is also at page 209A.
Yes, my lord. It has been annexed twice, my.
Twice, sir.
It has
Yes,
been
yes.
annexed twice.
Next.
This one forms a part of the written submissions.
Yes.
2 kata or 3 kata plot of land of Sector 1 was not 2 or 3 kata of land of Sector 1 was not allotted to a person who had landed property in the CMDA area. With cabinet approval dated 13/8/77, this restriction was made applicable for residential plots in sector 2 and 3 as well. Well, so in case of 2 and 3 cut of plot of land, such declaration is required in case of sector 1, sector 2 and sector 3. This is what I understand. In respect of 4, 5 and 6 cut of plot of land of sector 2 and 3, the cabinet in their meeting on 13/8/77 decided that the persons having separate house in CMDA area will not be eligible for residential plot in sector 2 or sector 3 of the township. The relevant portion of the cabinet note reads as under. But this is an extract of the cabinet note. In sector 1, no 2 or 3 cut plot of land plot was allotted to any person who possessed any landed property in CMDA area. This restriction may remain in force for other sectors also. But the next line is very important. For 4 cut plot, this restriction was waived subsequently.
Then why did why it is saying that the restriction? Kindly come to page 32 now. Keep this page open.
Yes.
Page 32, the finding of the learned judge. Cabinet decision dated 5th November 1979. 79 cabinet decision, where is it? That is not before us.
No, my lord.
222.
The cabinet decision, the 79 cabinet decision is before my lord, which is at page 222.
223.
Yes, from 223. It's a typed copy. Page 223 is a typed copy of page 222. So this is a cabinet decision of 5th November 1979.
This is 9th November 1979. Left hand side bottom.
It is held on 5th November 1979. My lord, I think my lord.
Court refers to as
at the bottom, my lord sees the date 9th November 1979. At the bottom.
9th November. Court
My lord, at the
refers
bottom,
to it as
left hand corner.
page.
Page 222 or 223.
Very good. Now kindly come to page 32.
Page 32.
Yes. How did the learned judge deal with this issue? We want to know. Clause 3, cabinet decision dated that page 222 proposed that restriction imposed in 2 or 3 kata in sector 1.
My lord, that is what I'm challenging. This is nowhere to be found in the.
He also imposed in respect of 4, 5,
my lord,
6 katas in Salt Lake. The restriction was extended in respect of 4 and 5 kata plots of sector 2 and 3, subsequently extended to all plots.
My lord,
where do we find it?
My lord, this is something I could not find in the cabinet policy itself, my lord. My lord, reads the entire cabinet policy, my lord. I think that will be.
No, we will question. Yes. Then next.
Para 5 mention. Para 5
Para-
mention. Para 5
yes.
of the cabinet. Vidisha.
Achha. Para 5 is at page.
It's set out in the order also, reviewed order also.
My lord, sees paragraph 5.
Set out in bold.
Set out in the order impugned.
Order impugned also.
My lord, paragraph 5 of the cabinet decision. My lord, if I.
31. Para 5 and 6.
In this connection. Paragraph 13, no? Yes, madam.
So, in this connection, it is felt that a person.
Mr. Baj, let her finish. He will. Which page you want us to see? Tell us.
My lord, page 224.
Page 224.
Yes.
Achha.
My lord, I was reading from the inverted commas set out in paragraph 2. In sector 1, no 2 or 3 kata plot was allotted to any person who possessed any landed property in CMD area. This 4 kata plot, this restriction was waived subsequently. It is proposed that the restriction be imposed that the owners of separate house in CMD area will not be eligible for 4, 5, 6 kata plot of land in Salt Lake. So this particular paragraph, which is an extract from a meeting held on 13th August 77, relates to a sector 1 property, and it also speaks of 4 kata plot of land of which the restriction was waived. And there was a proposal that the restriction be imposed, but there is no approval of the proposal on record.
Sector 1, 2, 3 kata was allotted to any person who possessed any land in KMT. This restriction is included for other sectors also. A 4 kata plot. How does it? What is your argument?
My argument is that for 4 kata of land, perhaps there was a restriction.
Restriction was of having
subsequently.
No, restriction was regarding having any landed property in KMD area.
Yes, and it was waived. There was a proposal again.
But in your case, it is you are a co-sharer in respect of another property in Salt Lake
property,
which is not under KMD. Then what is your argument, madam? What?
My lord,
you are meaning for 4 kata, this restriction was waived. That is of having plot under KMD. Very good.
If at all.
Now it is proposed that restriction be imposed that owners of a separate house again in CMD area and not co-sharers
will not be eligible for 4, 5, 6. So there was a proposal, but there is no approval of the proposal. And even if
this proposal will not apply to you because
if not, my lord, they have produced this cabinet decision. Since there is a whisper of sector 1, 4 katas, my lord, I think I should place.
So your case is that you are not having another property in KMD area.
In Salt Lake, yes, I have.
This clause does not refer to any ownership or co-sharership in Salt Lake area.
Owners of a separate house in CMD area and not co-sharers.
So CMD, this does not attract you, na?
It does not.
Then which clause you are showing us?
Well, I'm showing the entire policy, whether it is applicable to me.
No, your claim has been turned down on the basis of para 6.
Yeah, para 5. Para 5, my lord, comes to para 5.
Yes, show us that para 5.
Which is page 226. The typed copy is at page 227. In this connection, it is felt that person having the following quantum of land or building may be deemed to be the holder of sizable land. In Calcutta Corporation area, persons who have separate buildings, persons already having land with or without any building in Salt Lake Township, persons having more than 2 katas of vacant land, persons having building on more than 4 katas of land in CMD area outside Calcutta Corporation, persons having more than 4 kata of vacant land in the CMD area outside Calcutta Corporation. And it is accordingly proposed that the restriction on having a Salt Lake plot may be only in respect of the persons defined in paragraph 5. But the paragraph 5, my lord, in my respectful submission, this relates to plots in sector 2 and 3. The entire cabinet policy, begins with the words eligibility for residential plots in sector 2 and 3 of the Salt Lake Township.
And in that clause B says, paragraph 5, clause B says,
persons already having land
with or without
building in the Salt Lake Township, including Dhapa rehabilitation site.
So if you have that, you will be construed, it will be deemed that you are the owner of a sizable land. Now,
Yes,
why
my
this, where from the sizable land comes? Paragraph 5, second line. Deemed to be a holder of sizable land. So if you are the holder of a sizable land, you will not be able to be getting any property pertaining to sector 2 and 3.
Sector 2 and
not in respect of sector 1.
This. So
Very
this
good.
approval
So your argument is this clause is not applicable in your
not
case.
applicable, my lord.
But we are saying page 28. Why does the learned judge say subsequently extended to plots of all sizes?
My lord, I do not know, my lord. This cabinet policy, my lord. The
So
entire express on the
your
cabinet
first
policy.
argument is there is no, under the statute, there is no requirement for production of any affirmation of any affidavit. First, even if that has been brought into effect by a policy decision, that policy decision is not applicable to me. These are your two grounds of challenge.
This is the pith and
Any
substance.
other ground of challenge you have?
This is the pith and substance of my agreement,
Alright.
my submission, my lord.
Now let us, you will tell us in reply. Let us hear him. What does he say? You want to rely any judgment?
My lord, I will give the judgment after he concludes, my lord, on the next day.
আজ বলো কি বলছো?
My lord, one judge, the judgments which I've relied are part of the appeal itself because I filed the written notes. The judgments are there, my lord.
It was what? Heard by another bench?
My lord, I will place it again. That's why. My lord, it was heard before by the learned trial court, my lord.
Oh, acha, acha.
My lord,
Acha, let us hear him. What does he say?
and one judgment. My lord, this judgment, I'm only relying to the extent that a person cannot be compelled to give an affidavit. That is reported, my lord, in 2000. Hello?
2010.
Yes, 2000.
Volume 5.
Yes.
Maharashtra
Law Journal.
Law Journal.
Yes. It's a 3 judges bench, my lord.
465. Paragraph?
ACC only you get me. My lord, paragraph 12 and 13.
কি দেখছো? 1230.
And the judgments which I have relied upon before the learned trial court, my lord, they are part of the written submission. If my lord so desires, I will submit it.
Where is your written submission?
A part of this.
You have filed any written? Oh, before the
learned trial court.
Achha, let us. Oh, that you have annexed here.
Yes, I have annexed.
Okay, নিয়ে
And it's at page 213.
My brother is a very fast reader. Na, before I could go to 213, he has read 565. Yes, Mr. Banerjee.
My lord, I find the bone of contention or principal argument of the appellant is that the restriction imposed by the cabinet decision was in respect of sector 2 and 3, doesn't extend to sector 1. That is why they are not covered. Firstly, my lord, that
and you cannot compel him to give an affidavit because in your original letter at page 90, that page 118, there was no reference to a filing of any affidavit.
we cannot compel, my lord, but that is a precondition, my lord, for getting the final allotment. That is a precondition. Now, they might not get a lease deed from somebody, but unless the government approves that, my lord, we can approve or we can take the decision either to approve or not to approve. If the government decision is not that, if a person is having another plot of land in Salt Lake, we shall not allot a land to that particular person. It is a beneficial scheme, my lord. So we can say we are not approving the allotment. We cannot compel him that you have to file. But because of that non-filing, we can take a decision not to finally approve the transfer.
No, if there is no provision under this scheme that I can get a Salt Lake property only after affirming an affidavit, then we can understand that. But you're saying that we are not compelling her to give anything. It is up to our discretion.
Our discussion, since it is a beneficial scheme of allotment, and the government has taken a decision that it shall not be allotted or granted to a person having several plots of or other plots of land in Salt Lake area. It shall only be granted to the persons who do not have any sizable quantity of land in KMD area.
Then why did you incorporate the sector 1, sector 2, sector 3, 2 kata, 3 kata, 4 kata, 5 kata? You could have
From
written
time
a
to time,
single line.
no, from time to time, various decisions were taken. Those are quoted in the cabinet decision in question. But if your lordship can kindly take up the
So
cabinet
what
decision.
is your argument? Your
My
argument
submission
is
is, my lord,
we are not compelling him to give.
no, but we shall not finally approve it unless he or she fulfills not the particular criteria of not having a sizable quantity of land in KMD area.
So, madam, your client can suddenly say, give a declaration that he doesn't have any land in KMDA.
My lord,
Thereafter, they will take the decision.
my lord, if I'm not covered under the affidavit, under the cabinet policy, my lord, and that affidavit stresses to a great extent that this is you are legally bound to give an affidavit.
Because the Honorable Court went on to record that there's another writ petition where the petitioner was also a writ petitioner.
Yes.
In respect of another plot of
co-sharer,
land, he was a co-sharer. So that is already there. So she cannot give the affidavit.
Co-sharer in not in a CMD area.
In a Salt Lake.
No, not in
So
in
it's
Salt
not-
Lake.
Yes.
In Salt Lake.
That is not covered in the cabinet decision.
But if it is not, if the cabinet decision is read to be covering all the sectors, my lord, then it is.
That is not there in the
That is
cabinet.
there. May I just place, my lord, what was approved? If your lordship not takes up the cabinet decision, my lord, it says the approval part I am showing, page my lord 208.
408.
208. 208, my lord. There's a typed copy, my lord. 208 capital A.
Paragraph 6 approved.
Yes. Proposal contained in paragraph 6 of the cabinet memo approved. So this is the approval. Now kindly come to paragraph 6, my lord. Paragraph 6 is, my lord, it is accordingly proposed that the restriction on having a Salt Lake plot may only be in respect of persons defined in para 5 above. That is a general restriction.
Paragraph
211 capital A. Paragraph 211 capital A.
Approved.
211 capital A.
Right.
Now, my lord, it is in respect of persons mentioned in paragraph 5. Now, paragraph 5, my lord, says who are the persons having sizable quantum of land. Paragraph 5. That includes, my lord, 5B, persons already having land with or without building in Salt Lake Township, including Thapa rehabilitation site. So, persons having land in Salt Lake Township would be deemed to be holding sizable quantity of land.
For sector 2 and 3.
That is not the interpretation given by the petitioner. It is not for sector 2 and 3. It's a general discussion. Previously, what was the decision that is discussed? The initial part of
subject is eligibility of sector 2 and 3.
No, but subject is, my lord, kindly come
Page
to the
209A.
my lord. Kindly, maybe, my lord. But what is ultimately approved, it is in respect of, my lord, all the sectors. If the decision is read as a whole, my lord, initially it was in respect of, my lord, some areas restriction was there, some area restriction was waived. Subsequently, a proposal was given that the waiver should be given. Kindly then allow me to place, my lord, just the decision, my lord. I'll just, my lord, place. After the subject, 2 kata or 3 kata plots of sector 1 was not allotted to a person who had any landed property in CMD area. So it is discussing sector 1 also, not that.
No, it's not discussing sector 1.
The first line of the
Read on.
fine. With cabinet approval dated 13th of August 77, this restriction was made applicable for residential plots of sector 2 and 3 as well.
Correct. So
this
this
is not the background.
in 1 is also made applicable to 2 and 3. Doesn't discuss one.
This is the background, my lord. This is the background under which, my lord, the decision was taken. But the decision, my lord, cannot be, kindly see, my lord, a policy decision cannot be in respect of, my lord, 2 plots or 2 sectors and 1 sector is left because it has to be, my lord, read.
We are also surprised. Show us that line that sector 1 more than 4 kata is a sizable land under the cabinet.
That is paragraph 5. What is sizable land? That is, my lord, paragraph 5.
Paragraph 5 does not mention sector.
It does not mention any sector, sectors. It is the general, my lord, what is
Mr. Banerjee,
5B,
how can you
5B is
overlook the subject?
not 5B.
How can you overlook the subject? 5B has to be read in consonance with the subject, which relates to eligibility of residential plots in sector 2 and 3.
But it clearly says having land with or without building in Salt Lake Township. Salt Lake Township, my lord, doesn't, then it would have been, my lord, sector 2 and 3. What is sizable land has been described as not land in Salt Lake Township. We cannot not restrict it, my lord, by reading it, because ultimately 5 was the sizable quantity of land that has been approved.
But very good. If we accept your plea, come to 210 capital A.
210, my lord.
That is paragraph 4.
My lord.
I don't know whether it is paragraph 4. It is, I think, 3.
4. Lord, that apart,
allotment of 2 or 3 quota plots in sector 2 has been made through lottery.
There was a public announcement. No, this not came in the backdrop of a public announcement, which was in respect of 2 and 3 only. That was held to be bad. A public announcement was made for public sector 2 and 3.
Please come to clause.
My lord. My lord. May I read 210A?
This apart, as per cabinet decision in respect of
4, 5, 6 kata plot, only owners of a separate building in CMD area are not eligible for a Salt Lake plot. This means persons having sizable quantum of vacant land in the CMD area are eligible for Salt Lake plots. It is felt that like owners of separate buildings, holders of sizable quantum of vacant land also should not get Salt Lake plots. The earlier cabinet decision therefore needs change in this respect. So the matter as a whole was considered, my lord, because the government will not consider, my lord, sector 2 and 3 in segregation of the other sector. This is one logic. Secondly, my lord, this 4.2 clearly says what was in the mind of the, my lord, persons laying down the note. It says regarding Salt Lake. And 5 is also, my lord, not qualifying, my lord, 2 or 3. It is saying in Salt Lake Township. 5 has been approved. In paragraph 6, it is recommended, which is ultimately approved.
Persons already having land, with or without it, including in Salt Lake Township, including Dhapa, here.
Interpretation of already having land with or without land in sector 1
In respect of 2 and 3.
Oh, this is 4.
4.2, your lordship, I have placed 4.3, which says it should be in respect of all plots. Then 4.3 is a slight departure. As the public announcement was not strictly in accordance with the cabinet decision, it is proposed that in respect of all sizes of plots, the restriction may be as under. Persons who have sizable land or building in the CMD area will not be eligible for residential plot in sector 2 and 3. This was in connection with the public announcement, because announcement was made in respect of 2 and 3, there was some anomaly. While considering that, it is again said no, announcement was incorrect, because it should be all plots of land in connection with sector 2 and 3. But this does not mean that sector 1 will be excluded from the purview, because the previous paragraph clearly expresses the mind that it should be in respect of plots of land in Salt Lake. And 5 again, my lord, 5B again makes it clear in respect of all kinds of plots in Salt Lake. And now, if
kindly come to paragraph 2. Please let us read together.
My lord, may I?
Subject is sector 2, sector 3.
My lord.
Aspera is 2 kata, 3 kata
Of sector 1 was not allotted to a person who had any landed property. With cabinet approval, this restriction was made applicable for 2 and 3 also. Then in respect of 4 kata, 5 kata and 6 kata plots of sector 2 and 3, cabinet in their meeting dated 13/8/77 decided that persons having separate house in CMDA area will not be eligible for residential plot in sector 2 or sector 3 of the township.
Now,
Relevant portion of the now that note is not quoted.
Yes.
Is as under in sector 1, 2 or 3. In sector 1, no 2 or 3 kata plot allotted to any person who possessed any landed property in CMDA area. This restriction may remain in force for other sectors also. For 4 kata plot, this restriction was waived subsequently. It is proposed that restriction be imposed that owners of a separate house in CMDA area and not co-owners will not be eligible for 4, 5, 6 kata.
After withdrawal, the proposal was
again
separate
propose.
house in KMDA.
In KM. So
but
propose.
not Salt Lake Township.
Now, KMDA has been defined in paragraph 5, my lord. CMDA has been defined. Sizable plot of land in CMDA. Paragraph 5 says, in this connection, it is felt that person having following quantum of land may be deemed to be holder of sizable land.
Not KMDA.
But not the previous land, previous paragraph 4.2 says person having quantum of vacant land in CMDA area.
But they do not have in KMDA. They are having in, admittedly, they are having a plot of land more than 4 kata in sector 1. Show us where is the restriction in your cabinet, because your opposition says that first you have argued that as per declaration we can always ask for whether we will give or we will not give, that is our decision, but we are not compelling you, we are asking you to give, and her contention is which power empowers you
to ask for the affidavit.
Ask for the when in page 118 you did not seek.
No, but not for this cabinet decision we can ask. If it is the government's policy, we can ask for it. If we cannot compel. That is another thing. We cannot compel her for filing the affidavit, but we can ask for the affidavit, and if the affidavit is not filed, we can say as per our policy, you will not get the allotment.
So you satisfy us.
My lord, 5 and 6. I repeat, not 5 and 6. 5 I have placed, my lord. Then kindly comes to 6 once, my lord. It is accordingly proposed that the restriction on having a Salt Lake plot may be only in respect of persons defined in para 5 above. That is the restriction. And 5, what is para 5? Para 5 says, 5b says in Salt Lake Township.
Sizable land.
Yes. So 5 defines what are the persons having sizable land. 6 says you are falling within 5, then the restriction should be there. And 6 is approved in the meeting. The first page. So 5 and 6 read together, along with the initial note that 6 is approved, means it is in respect of entire Salt Lake. 5 and 6.
Kindly come to 208.
My lord.
Then what do you say about this?
208 note is the proposal. I've already placed it.
This is the decision in the cabinet.
Yes. The proposal contained in para 6 of the cabinet memo. Read approved.
Subject.
Subject above.
Eligibility of plots in sector 2 and sector 3 of Salt Lake. Subject was, the next page was also same. So the subject, my lord, we have to see the content. Paragraph 5 and 6, my lord, we have to read, my lord, as a whole. The intention was, my lord, very clear in paragraph 5 and 6. Persons holding land in Salt Lake Township. It is not saying in sector 2 and 3 of Salt Lake Township.
Sector 2 and 3 comes within Salt Lake.
Only because of it comes within Salt Lake. But if it says Salt Lake Township cannot be restricted to 2 sectors. This is my reading, my lord.
Cabinet decision. What was your problem in incorporating sector?
The subject, my lord, had the subject been clear, Salt Lake Township would have been clear. This is only placed because of
B.
5B.
It says persons already having land with or without building in the Salt Lake Township, including Dhapa Rehabilitation.
Right.
So if you are considering all of Salt Lake, how do you interpret this? If all sectors are in consideration, then persons having land with or without building in Salt Lake Township is excluded from which other part? If all of Salt Lake is being considered,
with or without building in Salt Lake,
right, then which part are you excluding? Ah, হতেই পারে না।
no, it is not excluding anybody, I am saying.
Persons already having land. এটাই বলছে maybe deemed to be a holder, following quantum may be deemed to be a holder. তাহলে তুমি সেক্টর 2 and 3 যদি পেতে চাও তাহলে সল্ট লেকে জমি থাকা চলবে, এটা একটা ইন্টারপ্রিটেশন। কিন্তু তুমি যদি কোথায় ল্যান্ড পেতে চাও তাহলে সল্ট লেকে জমি থাকা চলবে না। ও তো বলছে দিস হ্যাজ টু বি রেড অ্যাজ এ হোল, সো এন্টায়ার সল্ট লেকে তুমি জমি পাবে। তাহলে এই জিনিসটাতে কোনো মানে
if the finding is not restrictive, only because of the subject, because the matter came up in respect of a public announcement in respect of sectors 2 and 3. I have shown your lordship, my lord, that was also read down. Sector 2 and 3, there was a public announcement only in respect of some particular size of plot. It was said that is not in consonance with the previous policy decision. So maybe that because of that, the subject has crept in regarding 2 and 3 kata. But the intention is very clear in my humble.
But these persons previously approached the court also.
These persons jointly in another writ application that is recorded in the order of the honorable.
Then, why were you showing that? For what reason?
For the reason that she is having another plot of land which she has not disclosed in the writ petition.
But it was never their case. It was the inquiry and an investigation carried out by the learned trial judge. Nowhere they has taken this point at any point of time before the trial court, either in the affidavit or in the course of submissions. And my lord, if looks.
But it is a fact you are having.
It is a fact. It is a fact. I was with my elder brother. Now I live separate.
Ajay, madam, please.
And one more thing I would like to point out. My lord, a lot of stress is given on paragraph 5. My lord, comes to paragraph 3. In the advertisement in the newspapers inviting application for sector 2 plus, it was announced. So there was some anomaly in the advertisement. So paragraph 5 says, in this connection. So in connection of what? Of the plot of land of sector 2 and 3.
Where you are getting in this?
Minor comes to paragraph 3 first. In the advertisement in the newspapers inviting applications for sector 2 plots, it was announced that the persons having sizable land or building in CMDA area will not be eligible for residential plot in sector 2 in the township. The public announcement was therefore not strictly in consonance with the cabinet decision. So it was in the case of sector 2. Then paragraph 4, allotment of 2 or 3 kata plot of land in sector 2 has been made through public lottery in the course of, so it all relates to sector 2. Sector 3 my lord, sector 2 and 3 and in clause III, as the public announcement was strictly not in accordance with the cabinet decision, it is proposed in respect of all sizes of plots, the restriction be as under. Persons who have sizable land or building in the CMD area will not be eligible for residential plot in sector 2 or 3 of the township. In this connection, the next paragraph, paragraph 5 starts. It cannot be read in exclusion to its earlier paragraphs. In this connection. So whatever is
the public is not strictly in accordance with cabinet
in
decision.
paragraph 5, my lord, in my respectful submission,
Respect of all sizes of plots in 2 and 3. In 3 of এবং in this connection
so whatever it is, my
তার কোনো টাউনশিপের থেকে Now, why they are including Dhapa rehabilitation site there?
my lord, policy decision, my lord, I'm unable to it is a policy. It is the policy of the state. It has been considered by the cabinet. And my lord,
To show us an authority that we should not restrict ourselves to the subject of the cabinet decision.
and for my personal benefit,
And you please ascertain whether in respect of more than 4 kata land, everywhere you have insisted upon an affidavit.
My lord.
Because your affidavit in opposition is silent about that.
not only that, at page
I shall
132,
kindly allow the interpretation of the
affidavit
decision is the subject matter here.
page
So I'll have to
132,
Then
kindly
you have to,
give.
you have to prepare yourself. Na?
My lord.
Advance.
How it will be interpreted? Kindly not give me some time, my lord. I'll try to assist your lord.
And you call your officers also.
My lord.
That why? Because this will, if we hold in our favor, then in future you cannot restrict any transfer or having any other portion of it.
This will not have effect throughout sector 1. This
sector 1
decision of your lordship will not that will
more than 4 katas.
there is
Hard plot is more than
4 katas.
When can you come? You tell us. She has completed her arguments.
Kindly give me 1 week's time, my lord, next week.
my lord, another thing my lord will note at page 136, which is a part of their affidavit in opposition. My lord, the second paragraph, they say the answering respondents crave leave to produce the affidavits of Sudhanshu Ranjan and Pradeep Sinha at the time of hearing. Such affidavits were not produced.
Page 130.
136. This is a part of the affidavit in opposition.
They're the original lessees. Original
Yes.
lessee.
Sudhanshu was the original lessee, and thereafter Pradeep came into the picture. They crave leave to produce the affidavits.
What are these letters?
affidavit. ওরা ওই আন্ডারটেকিংটা দিয়েছিল আর কি দিয়ে দেখাতে চেয়েছি
Well,
Oh, acha, acha. You bring page 136 then. Produce this. Are annexed, it is said.
চিঠিগুলো অ্যানেক্স করে
No, the offer letter was annexed.
অ্যাফিডেভিট গুলো অ্যানেক্স তাই আমরা ক্রেভ লিভ টু প্রডিউস
At page 170, the application form.
So she is right, Mr. Banerjee.
My lord.
You get hold of these 2 affidavits.
My lord, I shall.
Which you have craved leave to.
Then
কেন ভুল হতে বলবে সাথে একটু সংকট। Ms. Roy Choudhury, learned advocate appearing for the appellant, has concluded her arguments.
My lord is pleased to fix any particular time, or it will appear at the top
For
for orders.
Madam, let it appear. If we cannot reach, you will be
No,
there.
no,
You
no.
remind us, then we can fix.
Fine.
Because
I'm grateful.
sometimes 2 p.m. we fix, but the
No, my lord, it's difficult.
yes, call Mr. Banerjee's matter. Yes. কত নম্বর? Yes, which is your matter? ওটা লাল কালি দিয়ে রাখো তো কালকে। Settle it, Mr. Banerjee. চলো।